Courtmaster, am I audible?
Sir, no audible.
Courtmaster, sir, am I audible? Courtmaster, sir?
ಎಂಟರ್ನಾಗ ಟೂನಾಗ ರೀಚ್ ಆಗ್ಬೇಕಲ್ರಿ ಸರ್. ಸರ್ ಬರ್ತಾರೆ 41.
ಪ್ರಿಂಟ್ ತೆಗೆದ್ರೆ ಮತ್ತೆ ಕೈಲೇನೋ ಬರ್ದು ಸರ್ ಅವ್ರ ಅರ್ಜೆನ್ಸಿ ಬರೀ ಬರ್ಕೊಂಡು ಪ್ರಿಂಟ್ ಮಾಡ್ಕೊಂಡ್ ಬರ್ರಿ ಅಂದ್ರೆ ಪ್ರಿಂಟ್ ಆಮೇಲೆ ಮಕ್ಕೊಂಡ್ ಬರ್ತಾನೆ. ಈಗ ಸದ್ಯಕ್ಕೆ ಇಷ್ಟ ಬರಿಬೇಕಂದ್ರೆ ಅಂದ್ರು ನೋಡ್ತಾರ ಆಮೇಲೆ ಬಂದಿದೆ ಇವತ್ತು. ಹೌದು, ನಂದು 9 ಇದೆ. 9 ಸ್ಟಾರ್ಟ್ ಹಾಕಿ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಅರ್ಧ ಕೊಡ್ತೀನಿ, ಜಲ್ದಿ ಬರ್ತದೆ. ಲೇಟ್ ಆಗೋಂಗಿದ್ರೆ ಬೆಳಗ್ಗೆ ಕೊಡ್ತಿದ್ವಿ. ಹತ್ತಂದ್ರೆ ಅಂದಾಗ ಹೇಳ್ಕೊಡ್ತೀನಿ. ಮೇಡಮ್ ಅರ್ಜೆನ್ಸಿ ಬರ್ದೀವಿ ನಾವು ಇದ್ರೆ ಇಷ್ಟು ಒಂದು ಫುಲ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬರ್ತೀನಿ. ಈಗ ದೇವ್ರಿಗೆ ಅನಿಸ್ಬೇಕಾದ್ರೆ ಮೊದಲು ಪೂಜಾರಿಗೆ ಅನಿಸ್ಬೇಕು. ಅಲ್ಲಿ ಈಗೇನೋ ಅಲ್ಲಿ ಹೊರಗೆ ಹಾಕ್ಲಿಕ್ಕತ್ತಾರಂತಲ್ಲ ಮೆಮೋ, ಅಲ್ಲಿ ಜೋತ್ ಬಿಡಿದ್ರು ಅವನು ಅಲ್ಲಿ ಹೊರಗೆ ಹಾಕ್ತಾರಂತ. ಹೌದು, ಇಲ್ಲಿ ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ಅಲ್ಲಿ ಹಾಕ್ರಿ ಅದ್ರ ಸ್ಕ್ರೀನ್. ವಾಟ್ಸಪ್ ಬರ್ತಾವ ಒನ್ ಸಿಸ್ಟಮ್ ಮಾತ್ರ ಚಲೋ ಮಾಡ್ಯಾರ. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಕರೆಕ್ಟ್ ಇದು ಅಂದ್ರೆ ಮರ್ದಿಸ್ ಬಂದ್ಬಿಡ್ತಾವಲ್ಲ. ಯಾವ್ದು ಸರ್ 2-3 ಮ್ಯಾಟ್ರ್ ಆಯ್ತು. ಅರ್ಜೆನ್ಸಿ ಫೈಲ್ ಇಟ್ ಪರ್ಫೆಕ್ಟ್ಲಿ ಅಲ್ಲ ಈಗ ಮುಂಜಾನೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿ ಹೋಗ್ಬಿಟ್ಟು ಅಂದ್ರ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ ಪೋಸ್ಟ್ ಆಗ್ಬಿಡೋದು ನೆಕ್ಸ್ಟ್ ಡೇ. ಸರ್ ನಾವು ಇದು ಬಂದಾಗ ಸ್ಟಾರ್ಟಿಂಗ್ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಪಾಸ್ವರ್ಡ್ ಮೆಮೊ ನೋಡ್ಲಿಲ್ಲ ಬಟ್ ಇದೇನಾಯ್ತಲ್ಲ ಕರೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇ ಕೊಡ್ತೀವಿ. ಈಗ ನೋಡ್ರಿ ನೀನು ಮಾಡಿದ್ರೆ ಈಗ ಡಿಲೇ ಅಂದ್ರೆ ಸ್ಕ್ಯಾನಿಂಗ್ ಒಂದು ಸ್ವಲ್ಪ ಡಿಲೇ ಆಗೋದು ಕೂಡ ಬೇರೆ ಎಲ್ಲೂ ಡಿಲೇ ಇಲ್ಲ. KSDC ಅರ್ಚನಾ ಮೇಡಮ್ ಒಬ್ಬರೇನು ಬೇರೆ ಮತ್ತು ಅದು ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರಿಗೆ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರಿಗೆ ನೀವು ಮತ್ತೆ ಕೋಆಪರೇಟಿವ್ ರಿಜಿಸ್ಟರ್ಡ್ ಸೊಸೈಟಿ ಅಲ್ಲ ಇದು KSDC ಅವರಿಗೆ ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇರೋದಿಲ್ಲ. ರೆಡಿ ಇರೋದಲ್ಲ ಐದುವರೆ ಭಾಳ ಜಲ್ದಿ ಆಗಂಗಿಲ್ರಿ. ನಮ್ದು 11ಕ್ಕೆ ಮಾಡಿದ್ರೆ ನಾವು ಆರಾಮ ಹೌದಲ್ಲ. ಎರಡನೇ ಬಂತಂದ್ರೆ ಬಂದಾರಲ್ಲ ಫೋನ್ ಅಶೋಕ್ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲಿ ನೀವು ನಾವು ಕೂಡ ಹಂಗೆ ಹೇಳಿ, ಅದನ್ನೇ ಹೇಳಿ. Yes. With kind permission, these two MFAs of the land acquisition after scrutiny, my lord, it is found that they are to be placed before the division bench. Hence, a formal orders are required from this court. And
Yes,
One matter for, but one matter
all
for,
preliminary hearings, no mentionings. If any matter you are mentioning, there should be of urgency. Otherwise, please don't mention.
one matter for B group notes. My lord,
Give it to the court officer, all the memos mentioning the urgency.
I am, I,
If urgency is not there,
Yes, my
hang it outside the court.
I mentioned all the.
My,
Even though it's-
my lord,
Your ladyship, may I mention a matter? There is some urgency in it. It's a tender matter.
Lordship, kindly see the after, day after tomorrow, not sir.
Write you want day after tomorrow, why you want it, I'll look at it.
I mentioned.
Your ladyship, if I may mention a matter, we have moved a memo for it.
What happened to your memo?
Your ladyship, we've moved the memo. It's been given to the officer. Your ladyship is a tender cancellation notice which had been forfeited, and it's an
If the
MSME
memo
where
is
we had.
moved- If the memo is moved and there is no urgency mentioned, you will find the memos outside the court. If
Indeed, Your Lord.
reason is mentioned.
We've
it will be
moved the
looked
memo
into.
only
Please
today.
give the memo. Yes,
My lords,
all the list.
my lords, this
Page
is,
what judgments?
I'm sorry, my lords, this is insurance appeal, my lords. As they have deposited the entire amount before the tribunal,
You are
my
not
lords.
exception. Write the reason, give it to the court officer, it will come.
Kindly
Yes.
please have it tomorrow,
We
ma'am.
will, we'll see, we'll see.
Much obliged.
Yes,
Page what judgments? Page number 2, serial number 7, page number 3, 8 and 9, page number 4, 10, page number 5, 11 to 14, page number 6, 15 to 21, page number 7, serial number 22, page number 8, serial number 23 to 27,
My lords, 25.
Yes.
1 week time, my lord.
20,
1 week,
25.
why 1 week time?
because of some inconvenience.
This is matter in the month of March. At the request of land counsel, the petitioner. Yes,
Page number 9, serial number 28 to 36,
Serial number 28, my lord.
yes.
May I request next week, my lord, I'm appearing on behalf of petitioner counsel.
Dharwad Vidyashankar.
Preliminary hearing matters, why should we adjourn?
He has some inconveniences.
No, I'll look into it. I can't, we don't have time for, to adjourn these matters. Yes,
My lord, he has,
no, yes, 34?
Lord,
Pratap
I
SS.
request
Pratap.
10 days time, my lord, the authorities have assured me that they will redress my grievance, my lord. In case they redress, my lord, I will be having no case, my lord. They assured,
Matter on Monday.
16,
please, 10 days. please.
No. Yes,
page number 10, serial number 37 to 42, from admission, page number 16, 64 to 66,
Lord, serial number 65, Lord.
yes.
I appear for appellant. Just for a week's accommodation, Lord. Already informed the other side.
You have an
Swami
interim
Hireman.
order in this?
Sorry.
You have an interim order in this?
No, no, no.
Yes, this is matter in the month of March.
Please.
Page number 17, serial number 67 to 70, page number 18, serial number 71 to 74, page number 19, serial number 75 to 77,
Serial number 77.
77.
77. Last occasion, Lordship has directed to get the original records, Your Lordship. Original records, Your Lordship.
Then why you are not, where are they?
Not yet received, Your Lordship.
Will not adjourn, we will see what is the order, what has happened. Yes,
My apologies, serial number 71, I may mention. I seek for short accommodation.
why?
71.
There is some inconvenience. 2 days of accommodation, will argue the matter.
Ramesh Ajjarale,
I have informed the other side.
This is matter on Monday.
And there is an interim order.
Adjournments.
Please, my lord. There is an interim order, my lord.
The order will be extended.
Great.
Yes. Call the list.
My lord, serial number 80, my lord. My lord, the last occasion, my lordship has directed to file affidavit, my lord. But counsel for on the record, my lord, not feeling well, my lord. My lord, 2 weeks, my lord.
Lord, I appear for the petitioners.
I informed to the Chetan Munwale, my lordship.
I appear for petitioner, my lords.
Informed to the petitioner counsel.
Matter was heard at length, my lords, on previous occasion. My lord,
We'll see when the
lordship said
matter-
directed, my
My
lord.
lord, counsel is not, respondent counsel is not present, my lord. He is not feeling well. That's my lord. Next week, my lord, sir. Next week.
Matter on Tuesday.
Serial number
Please.
44.1, my lords. Appear for the petitioner, 44.1, my lords. May I request, my lords? Counsel on record is disabled before your lordship, my lords. Kindly delink that matter along with the 44, my lords.
both these matters,
My
44
Lord,
and
if I appear
44.
for respondent, I'm got the additional document. On
The
the last occasion.
44.1, please listen.
Please.
44.1, this court has already passed an order that the matters pertaining to Suhasky Postmani shall not be posted before the court. In spite of an order, the registry has listed this matter. As these, both the matters are connected, list before the other court. Yes. Next.
And serial number 80,
Page number
intermodal may
51,
my
Lordship.
lord.
I will withdraw this writ petition, Lordship.
Which one?
51.
Take
I am
that.
for petitioner.
You are seeking any liberty?
Yes, Lordship.
If you are seeking liberty,
No, Lord, sorry. Party has settled.
the memo is filed. Seeking to withdraw the petition, memo is taken on record and dismissed as withdrawn.
Lord, serial number 83.
51.
Serial number 83, my lords.
Yes.
We're for respondents, my lord, 2 weeks' time.
Have
We
you
already
informed the
informed
other
it
side?
to.
This is matter in the month of March. Please call the
One
list.
mention, my lords, in serial number 80, my lords, it was adjourned to Tuesday, my lords. There is an entry order that may kindly be extended.
Which case?
Serial number 80, my lords,
Interim, or if it is there, it will be extended. Yes.
please.
One.
Serial number 1, being spoken. Sanjay Katigeri.
And for the respond number 1, my lords, there is a small correction in the operative portion of the orders. Instead of mentioning it as dismissed, it is stated as allowed. On merits, it was disposed of.
The writ petition. This court on 19 January 2026 has dismissed the writ petition. But in the operative portion of the order, it is mentioned as the writ petition is allowed. Hence, the counsel for the respondent has moved this for being spoken to. Accordingly, in the order portion, it should be accordingly, the writ petition is, show it to Mega.
Obliged, my lords.
Writ petition is dismissed. And the corrected copy shall be uploaded. Yes.
Serial number 2, Sam Kalwat.
Yes.
The petitioner herein has filed the suit, my lord. Suit for declaration and injunction, my lord.
What is the for being spoken to?
My lord, what I meant, my lord, at the time of disposal, my lord, it submits that the evidence is not commenced, my lord. But matter is already, evidence of the PW1 is commenced and the matter is posted for DW1 cross, my lord.
Who asked you to make this submission before the court? Then it is not for being spoken to, it is review, file a review. It is submitted that basing on the fact that the evidence is not completed, the court had disposed of the matter, giving liberty to the petitioner to file an appropriate application at a later point of time. Now it has submitted that the submission that is made before this court is not correct, and he wants the order to be modified. If that is the case, the petitioner, if so decides, he can file the appropriate application, but for being spoken to, this cannot be clarified. Yes. Next.
For dismissal, serial number 3, R.H. Changdi, Gracious Fulmani.
In this case, I have filed a no-see wakala.
File a no-see wakala.
Please, I apologize, Lordship. In the last hearing date, due to the name of R.H. Changdi, I am not able to appear before this court.
You are?
I have filed an SP Dodagowd.
Delete
Please.
RH Angdi and SC, some other name is there, both delete. Yes.
In
Have
this
you
case,
prepared objections?
in this case, we have challenged the e-auction notice. After filing of this writ petition, the very bank has dropped that proceedings. Therefore, the petition become infructuous.
He is informed on the last.
Yes.
The land counsel appearing for the petitioner submits that. But the auction proceedings that are questioned before this court, where that side of auction was not conducted. And later when the auction proceedings were, the notice was issued, they have questioned it before the essay, by filing an essay before the DRT. And in your, as the auction, as per the auction notice is not conducted, nothing remains for consideration in this petition. Accordingly, dismissed as infructuous.
Much obliged.
Number 4, V.V. Somapur.
Please, my lord. Here in this case, the petitioners have challenged the order passed by the trial court, wherein the application filed by the respondent, who is the defendant in the trial court, has been allowed, and he has been allowed to file his return statement. On 1/3/2021, he was placed on ex parte.
Let's see the order. Order, where is the order?
Order dated 1/7/24, my lord. Order sheet has been produced. On 1/7/2000, page 44, Your Honor.
Case called out, counsel for the plaintiff has filed objections, heard both sides. The D1 has shown sufficient reason to allow the IA number 8 on cost of rupees 2,000. Let us see where is this IA number 8. I number 8, where is it?
I number 8 is that it pays 56, my lord. Pays 56. Here in this case, he has sought for a recall of the order dated 28th.
When was the suit filed?
Suit has been filed in the year that on 9/3/2020, my lord.
9/3/2020.
And he was placed ex parte on 1/3/2021. And application has been filed on 8/11/2023.
8/11? What is this IA number 8?
That IA number 8 is for recall of the order dated 28/6/2021.
Court has not given any reasons for that.
The court has not
Is there
only
any separate order?
no separate order. It is in page 44, my lord.
And 24 CRP is without notice pending till now.
Once.
No notice also from 24.
Notice, I think.
From that time, the suit must have proceeded by taking that written statement. And what is the purpose now? After 2 years, you must have been, because there is no interim order in this.
There is no interim order. I'll post it on day after tomorrow. I'll verify.
Please get instructions.
Please.
Let's just matter after tomorrow.
Please.
Yeah, 30.
Yes, next.
Seal number 5. BD Narsagon.
No representation. This is matter for dismissal on Tuesday. Yes, 6.
17.
But this is already under dismissal. Give that. This is a writ petition of 2024. Fine, till till 15/10/2025. The office objections are not complied with. On 21/10/2026, the matter has come up before this court. As there was no representation on behalf of the petitioner, the matter was directed to be listed for dismissal on 22/1/2026. Again, on 22/1/2026, there is no representation on behalf of the petitioner. As the matter is directed to be listed today, today also there is no representation. It appears that the petitioner is not interested to prosecute the matter, accordingly dismissed for non-prosecution. Then 6.
Seal number 6. Srikanti Patil. Santosh B. Malligwad.
The plaintiff's writ petition, my lord.
Sudhir Hiremat.
I'm challenging the I number 2 of the file under order 16 rules, which has came to be rejected.
Page number.
Page number. Annexure E, my lord. Page number 47, my lord. 47.
You are the plaintiff or the defendant?
I am the plaintiff, my lord.
What is I8?
Please.
What is the I8?
I is for under order 16 rule 6, my lord.
Order?
16 rule 6 for to produce the documents and to lead the evidence.
Suit is of the year 2017.
2015, my lord. 2015.
17 it appears.
And that is, it is again renumbered as 2017.
It's a 15 suit.
Uh,
So please come to the impugned order.
Please.
Please read it.
The reasoning is given by the trial court, my lord. Total, my lord, suit is for declaration and injunction, my lord. The trial court has given that the total is joint owners of the suit properties of plaintiffs on the defendant number 1 and 2. And the defendant number 3 is a son of one of the brother of the plaintiff number 1. Plaintiff he is claiming as a son of the one of the brother Panduranga. As per the genealogy, my lord, as produced at page number 13.
Let's read the order, then you can make your submission. Please
Please.
read the order.
Only my grievance is, my lord, to produce the documents as
Read the order, Mr. Counsel, at page 47.
please. Under order 16 rule 6 CPC is in simple language. It is stated that any person may be summoned to produce the documents without being summoned to give evidence, and any person summoned merely to produce the documents shall be deemed to have complied with the summons if he causes such documents to produce instead of attending personally to produce the same. The effect of this rule is that court has authority to summon any person to produce a document, or it is a cause to be produced before the court in compliance with such a summons. It is due compliance of order 16 rule 6 of the CPC. Next. So as per the order 16 rule 6 of the contemplates only about production of the documents through some person. It does not speaks about leading the evidence through that person on the said document and to examine that person who is produced the document and the applicant out to have filed the application order 16 rule 7 CPC. This is a one flaw in the application which is to be taken note of. Further, in my considered opinion, after having gone through the plaint arguments, it is disconnectable from the facts and circumstances of the said case that the relief sought for the instant application and the relief claimed in the suits are totally contradictory to each other. And the plaintiff ought not to have sought for the relief of declaration to declare that he is a joint owner of the suit property against all the defendants in the plaint prayer, and ought to have excluded the defendant number 3 from the said relief. If he is were to seek the such relief, then he could have not denied the relationship status of the defendant number 3 with his joint family. When he has sought for declaration to declare that he is a joint owner of the suit property against all the defendants, then it is invariably amounts to admitting the relationship with the defendant number 3. The plaintiff in the prayer column has not sought for the relief of declaration to declare that he is a joint owner of the suit property along with the defendant number 1 and 2 only, wherein he has sought for the relief of declaration against all the defendants, thereby admitting the relationship of defendant number 3, which is with his joint family. Merely denying the relationship of the defendant number 3 in the body of the plaint without seeking any suitable relief in that regard.
Defendant 3 is unconnected with your family. Why did you implead him?
He is disturbing possession, my lord. He disturbing
Come to the plaint.
Please.
Where is the plaint?
At page number 17.
What did you say with reference to defendant number 3?
In body of the plaint, I have declared in body of the plaint, I have pleaded that.
Please come to the plaint. What are the averments against defendant number 3?
In prayer, my lord, plaintiff may be declared as the joint owner.
What is your prayer is? The plaintiff may be declared as a joint owner of the suit properties and consequently
The defendant.
and men on their behalf of the so and so be restrained.
Please.
According to you, along with defendant number 3, you are also a joint owner. That is a declaration you sought.
Only plaintiff and the defendant number 1 and 2 are the joint owners.
Look at it. What did you ask? Come to your prayer at page number 17.
But as per the exhibit D17 produced by the.
Think about him. What is the relief you are seeking?
Listen.
You are saying that he is also a joint owner. Now you say he has produced a document to say that he is a son of so and so, and you want the headmasters to be there to be summoned to prove that he is not the son of so and so. How is it relevant when you yourself have made him a party saying that he is one of the co-owner? That's how the rightly court has considered it. Yes, Mr. Counsel.
Please, Lord, the petitioner and respondents are joint family members. Well, there is a partition between their predecessor and my father. After the death of my father, my lord, we are in separate possession of our respective shares. Now, to deny my share, my lord, they have instituted this suit. Prior to this, my lord, there is another injunction suit that was dismissed for non-prosecution. I have stated in my written statement also. Page 21 is the genealogy, my lord. That is,
Please come. Agreed with the order passed in I number. What is this I number?
yes. I number 9, my lord.
Agreed with the orders passed in I number 9 in OS number 159 of 2017.
11, sorry, my lord. 11, I number 11. It's 11.
No, in the entire order sheet is numbered as OS number 159 of 2017.
It is renumbered, my lord. The page 47 is the imprint.
But
Page,
we have to look at the renumber.
yes, yes, please.
OS number 159 of 2017, dated, what is the date?
It is dated, my lord, 15/10/24.
7/11/2020.
7/11/24.
The plaintiff is before this court. The plaintiff had filed a suit seeking declaration that he is a joint owner of the suit properties and consequently the defendants and men on their behalf be restrained by decree of permanent injunction not to cause the obstruction and disturbance to the peaceful possession and enjoyment of the petitioner over the suit property. In the said suit, the petitioner plaintiff had filed an I number 9 under order 16 rule 6 to issue summons to the headmaster principal of Kendriya Shala Pur for protection of original register maintained by the school authorities regarding the school leaving certificate pertaining to the defendant number 3. Is it?
Yes, defend number 3.
3. And to lead evidence in respect of the document to meet the ends of justice and equity. The court by order impugned had dismissed the application. While dismissing the application, the court has observed that the relief sought for in the incident application, the relief claimed in the suit are totally contradictory to each other. And the plaintiff ought not to have sought for the relief of declaration to declare that he is the joint owner of the suit properties against all the defendants. And he ought to have excluded defendant number 3 from the said relief. If he were to seek such a relief, then he could not have denied the relationship status of defendant number 3 with his joint family. The court, looking at the prayer and the relief that is sought, which are contradictory to each other, and in those circumstances, an IA that is filed contrary to the relief that is sought, is not required and dismiss the application. Agreed thereby, the plaintiff is before this court. Land counsel appearing for the plaintiff submits that the court ought to have allowed this application as though the defendant number 3 is claiming to be son of Panduranga. Same is denied by the plaintiff. As such, it is very much essential to call for the records as he is relying on the school documents, whereas the original was not produced before the court. It is submitted that without considering all these aspects, the court had dismissed the IA. Land counsel appearing for the respondent defendant submits that court considering the prayer that is sought and the IA that is filed, which is unconnected with the relief in the suit, and as that issue need not be decided by the court had rightly dismissed the application, and there are no grounds to interfere. Next para, having heard so and so. The petitioner has filed an application to call for the records and also called for the headmaster to give evidence with regard to the paternity of defendant number 3. Why the defendant number 3's paternity has to be decided in a suit where you file the suit for declaration, seeking a declaration that he is a joint owner of the property along with defendant 1, 2 and 3. Why the third defendant's paternity has to be decided in this case? There is no nexus between the relief and the IA that is filed. The court had rightly considered and rightly held that such an exercise need not be done. Any evidence that has to be adduced has to be based on the pleadings, based on the issues that are framed. And contrary to the pleadings, there cannot be, he cannot choose to file any application and produce any evidence. In the considered opinion of this court, the court had rightly considered and passed orders. There are no grounds to interfere. Accordingly dismissed. Next.
Please, oblige.
Seal number 7, preliminary hearing matter. Antesh R. Patil.
My lords,
Prem Mali.
I appear for the respond number 1 in all the matters, my lords. May I seek next week, my lords?
Why
as
do you seek next week a writ petition of 24, 19? Why are they pending before this court?
Senior is out of station, my lords, some function in the hometown, my lords.
No, at request of the learned counsel, the matters will be adjourned today. Now, at request of the respondent, again it will be adjourned. And you have no urgency in a matter of 2019. In all the matters, stay is there.
Please, my lords.
Lord, stay is in respect of, my lord, a compromise petition, my lord, order is stayed, my lord. But they are enjoying the property, my lord. That is the.
Next week, any date, my lords.
From hereafter, I will adjourn the matters on cause. This is matters next Wednesday. No further adjournments will be granted.
Please.
Unfortunately, where matters are listed, adjournments are. Where matters are not listed, morning 100, 30, 40, 50 memos. I'm not able to understand what the bar wants. Yes.
Seal number 8, Jagdish Patil.
Suit for partition, my lords. Defendants 2 to 5 have preferred the present writ petition. They had filed an application for recalling of PW1 for further cross-examination, my lords.
When was PW1 cross-examined? When the cross-examination was closed?
My lords, his cross-examination was closed in the year 2019 only. In the year 2000.
Why you have realized now that he should be
Please, my lords, we produced some documents, my lords, exhibit D 85 to 92. For that cross-examination only in respect of
application allowed.
Application is rejected, my lords.
The documents.
No, during the course of our evidence, defendant's evidence, we produced it, my lords.
Which year? That's what I'm asking.
2024, my lords. 11/6/2024.
When this application is filed?
This application was filed recently, my lords.
Why?
My lords, since the cross-examination to the effect on those documents was necessary, my lords, the recalling application was
It is
filed.
necessary when
Please.
the documents are admitted. At that point of time, we should have filed an application.
It was not.
By the time the plaintiff's evidence was closed.
Please, my lords. Plaintiff's evidence was closed, my lords, was cross-examined.
Let's see. Let us see the order of the court.
Page number 189 is the order, my lords. Reasoning portion starts from.
Please read.
Please. Initially, this suit was filed by one Srimati so-and-so as plaintiff number 1 and so-and-so as plaintiff number 2 seeking partition and separate possession of the half share in the suit properties. It is the averments of the plaintiffs that these properties were originally owned by one Rudrappa. He had a wife by name Gauramma. They are no more. Subsequent to the death of Rudrappa in the year 1937, the names of his two sons, namely Gangadharappa and Huchappa, came to be entered jointly to the property extract of the suit properties. But the second son of propositors, namely Huchappa, without the knowledge of Gangadharappa, gave Vardi and got his only name entered in the property extracts of the suit properties. And subsequently, he got entered the names of his sons, that is defendants 2 to 5, to the property extracts of the suit properties without the knowledge of plaintiffs or Gangadharappa. The plaintiff number 1 is the wife of said Gangadharappa and plaintiff number 2 is his son. Therefore, the plaintiffs said to have verified the records of the suit properties and came to know about the said entries of defendants 2 to 5 to the property extracts of the suit properties, and they requested defendants 2 to 5 to allot their share in the suit properties. But the said defendants said to have refused to allot their share, hence the plaintiffs were constrained to file the suit. The defendants 1 to 10 are the wife and children of Huchappa. Defendants 2 to 5 have filed their written statement, and the same has been adopted by defendants 1 and 8 by filing memo. In the written statement, the defendants 2 to 5 have denied the relationship of plaintiff number 2 with plaintiff number 1 and with the deceased Gangadharappa, and they contended that plaintiff number 2 is not the son of deceased Gangadharappa and plaintiff number 1. It is further contended by them that in the year 1958 only, as per the family arrangement settlement held between the deceased Gangadharappa and Huchappa. The suit properties fell to the share of deceased Huchappa, and consequently his name came to be entered to the property extracts of the suit properties, and therefore the said defendants have contended that the deceased Gangadharappa did not seek partition within the prescribed time limitation during his lifetime, nor the plaintiffs have sought for their share.
Can straight away come to
So-
internal page 7, bottom, para 10.
In order to prove the case of plaintiffs, plaintiff number 2 got himself examined as PW1 and got marked exhibits P1 to P15 documents on 27/7/2017. The counsel for defendants cross-examined PW1 at length on 3 occasions, that is 27/11/2018, 5/12/2018, and 15/12/2018. Now, after lapse of almost 6 years, the defendants 2 to 5 are seeking recalling of PW1 for his further cross-examination, alleging that the further cross-examination of PW1 is necessary in respect of documents, that is exhibit D5, D85 to D92. If at all the cross-examination of PW1 on exhibit D85 to 92 is necessary to prove the defense of the defendants, under such circumstances, what prevented them to cross-examine PW1 earlier when they had cross-examined him on 3 occasions as stated above? No reasons are forthcoming in the affidavit of defendant number 2 as to why they did not cross-examine PW1 earlier. Further, it is pertinent to mention here that PW1 is said to be missing or absconding, and in connection with the same crime number 158 of 2024 in Haveri Town Police Station is also came to be registered.
Yes.
Please. My lords, may I take at least hand summons because my lords, these documents are produced during the course of my evidence, my lords. They were not available earlier. So during my evidence, I have produced these documents.
Court has observed even after that also
Please.
you didn't do anything. Now you want to delay the trial.
No, my lords,
You want to
that's-
delay the suit. Now you know that plaintiff is absconding
My lords,
in a criminal
assuming,
case. So now anyhow, if you get this order, anyhow it will not be
please, my lords,
possible.
assuming if the order is recalled, my lords, and if he does not come for cross-examination, if he does not tender himself for cross-examination, automatically I will not be in a.
A suit of 27/7/2017, exhibit P1 to 15 are marked. Defendant was cross-examined on 27/11/2018, 5/12/2018, and 15/12/2018.
Please.
After 6 years, you
Please.
filed this application.
Because, my lords, my evidence concluded recently, my lords.
When?
Thereafter that, defendant's evidence.
Your evidence was from 18 to 26.
Please, my lords.
6 years your evidence is going
Please,
on.
my lords, it's not only me.
Place the proceeding sheet.
Please,
The petition shall place before this
I'll
court
produce.
the proceeding sheet of the trial court. This is matter next week.
Please, in the meanwhile, my lords, I may be permitted to take hand summons on.
Not necessary notice. Yes.
Please.
Seal number 9, Girish Dharwad, Rajendra R. Patil, Srinande Pat.
This report has come, lords. I was pleased to appoint an advocate court commissioner. But yesterday he has filed the report.
There is a report. Yes.
But in the answer itself, my lords, what they say is there is no such pathway existing ABCD road as shown in the plan. The sugar cane is planted in the portion shown as ABCD. My lords. Recently, that is being done is my instructions, my lords. They have put the seeds, my lords, recently, and my lord, they have plowed the land. So, my lords, when the commissioner visited, my lords, what he says is, my lords, there was a pathway of 2 feet, but that is only in the, my lords, land of the respondent defendant here in, my lords, plaintiff. My lord, if other portion is seen, there is no other way also, my lords, alternate way, my lords. Even, my lords, videograph was, my lords, shown by the commissioner, my lords, because it was not made part of it, though he have stated in his this. That also we have seen, my lords, there is no alternate way, my lords, except this, my lords.
File whatever you want to file, your objections or your this thing to this, you file.
Yes, but meanwhile, my lord, now what has happened, my lords? The photos, if your lordship would see,
No,
the
no,
sugar cane.
tomorrow I'll take up.
Please, my lords,
Yes.
please.
This is not tomorrow.
Please.
By the time, if any objections to the report of the commissioner shall be filed by both the parties.
Please.
Only one clarification I wanted to subject to what, my lord. Second answer, my lord, has to be read with the first one. There he clearly says, even if in their land also, my lord, it's only a.
Wants to say,
Yes,
let
yes.
him say, we will decide tomorrow.
And it may also be noted that when this writ petition was filed, my lord, at that time I had produced photographs along with the memo. It's not that for the first time, my lord, I am showing that land.
Yes.
There has been a crop there, my lord, since much before.
10.
Please.
Serial number 10.
In serial number 10, my lords, the two
the
old
number?
matters, my lord, in RS, in WP number 5178 and 8116, my lord. They are also connected. But I'm withdrawing those two writ petitions.
Which one?
WP number 5178 of 2008, my lords.
Oh. And 10.1 and 2 you're with.
1 and 2, my lords, yes.
Give the memo.
Yes,
A memo is filed seeking to withdraw the writ petition, 10.1 and 10.2. Dismissed as withdrawn.
my lords may also kindly note that, my lord, I have taken the signatures of the petitioners on the memo.
Huh?
I have taken signatures of the petitioners on the memo for withdrawal.
Memo is there. Yes. Now please come to 10. What is this 10?
Lord, serial number 10, my lord, sir. I appear for petitioner.
Hmm.
I have engaged VM Shilvan sir in this matter, my lord. He is held up in quotal number 3. I request, my lord, sir.
Then what about the other matter?
Well, all these
10.3?
matters.
In
my
all
lord,
these matters, my lord, the
issue is
dispute
that-
is.
issue is that, my lord,
Let age.
under section 23 of the Karnataka Hindu Religious Endowments Act, my lord, this is a classified temple. My lord. This is a classified temple and notified temple. So after notification, my lord, before notification, my lord, under the old scheme, my lord, the district judge has appointed the scheme was framed, and as until today, my lord, the scheme is in operating. So they have appointed the district and session judge of the Dharwad has appointed the committee, and the scheme has been continued as in today. My lord. Now the writ petition has been filed. Appointment of the scheme is against the provisions of the Karnataka Hindu Religious Endowments Act. Now it is already notified temple. Therefore, in the view of the notification, the scheme framed by the district and session judge is not unsustainable, and it is wide ab initio. This will be only operating before the temple is notified. Once temple is notified under section 23, automatically this temple become an endowment temple. The district and the scheme itself is going to be lapsed, and district and session judge has no authority to constitute a scheme. This is a subject. All these matters issue.
Immediately I'll take up. Ask him to come after the matter. This matter will be called. Yes. No passover, short passover. Yes.
Please.
Yes, next.
Yes. Serial number 11. Pachap.
It's here,
Reconvene.
constitutional validity of not
Contesting
KPID Act,
is-
lords. A section was came to be amended.
Contesting is respondent told, my lord, Viresh Budhyal.
Is this the one the other day it has come up and you wanted to file an affidavit? Is it the case?
No, it's not. It's a different case, lords.
In the other matter where the validity is questioned, you want the
No, that is different. That is different. But here, my lords, what has happened? Under the KPID, my lords, it's a enactment for the protection of the.
By virtue of this, the entire power is given to the government.
Now they have included, my lords, one word: judicial decree, my lords. If I have to file a claim petition before the assistant commissioner that such and such society has been declared as fraud, and my money is there back, they have told that they will reconsider. In this, where they also say, Lord, we have to obtain a judicial decree.
Counters are filed in this, the objections
Lords, in fact, last two,
state
three
has to-
occasions, your lordship have granted time.
to file.
Please, they are required to file, not state. Lords.
Respondent number 12 has to file competent.
The amendment is by the state. Allah, competent authority, state amendment. State has to file, my lords. Last occasion,
File your objections.
We'll file your.
Or else we will say,
2 weeks.
state generally don't file objections. So every constitutional validity that's questioned, where it is deemed that it is unconstitutional.
Send a communication.
Huh?
Communication is sent, your lordship, 2 weeks time.
That's what we do. Now, when was this order?
lords, last occasion.
19/1/2026. HCGP seeks time for filing objections. List this matter on 10/2. Please take the order. This court on 19/1/2026 has passed an order. The proceeding shows that HCGP sought time for filing objections. Even till today, the state has not filed objections. When the petitioner is questioning the constitutional validity of the act, it is necessary that the respondent state shall file their objections. If they are not filing the objections, it means they, according to them, as pleaded by the petitioner, it is unconstitutional. List this matter on 23rd. By that time, if the objections are not filed, basing on the contentions of the petitioner, the matter will be heard. And after that, the right to file the objections will be forfeited.
Please, please.
Bill number 12, questions and should be.
Yes.
Lord, in the suit for specific performance, the defendant's application seeking permission of the court to file written statement is being rejected.
How many days?
9 years, my lord.
Huh?
After 9 years, they have filed application.
How can it be?
Lord, there are only 4 defendants. Now, defendant number 1, 2, 3 are before this honorable court. Defendant number 4 has expressed.
File this application after amendment or before amendment?
My lord, before amendment, my lord. Before
But
amendment.
for 9 years, how will it be?
Lord,
9 years, what are you doing?
Lord, even the trial court has observed that no reasons are assigned, but my right will be. Please,
Where is that order?
Lord, impugned order is at page number 16, the operative portion, at ink page 18.
Please read.
May I read from the reasons, my lord? Ink page 19.
To set aside the order dated 26/8/2016 and permit her to file the written statement. What
Please.
is the stage of the suit now?
My lord, stage of the suit is that defendant number 4 has expired. The LRs of the defendant number 4 is required to be brought on record. Notice is issued, but it is for their appearance. Of
Trial has not yet commenced even till today.
no, my lord. Plaintiff evidence is completed. Defendant evidence is not commenced.
Respondent.
Please,
Yes. Petition is permitted, take court hand summons.
please.
Seal number 30. What is your side?
Lord, I seek for weeks time to produce documents, man.
What documents?
Say original sale deed and,
Matter came up on 21, it is adjourned to
please,
22.
please, ma'am. I had filed 2 applications. Those applications for amendment, one for amendment of the scheduled property and one for a decree. So numbers have to be changed. The court has rejected my,
Times, 1 or 2 times you have already filed the
please,
amendment.
ma'am. Because of the plaintiff cannot enjoy the property. So
We
for that
don't-
purpose, I want to produce the,
Don't think even today it is going to be final, that this is the last time you will file this application. 2 times you have already filed application
Yes,
for
I-
amendment of the plaint. How many times the decree will be amended?
my lord, what has happened is in the sale deed, as per the sale deed, I had written the measurements.
This
For
is
that
matter-
purpose, I want to produce the
This
document.
matter in the month of March. Yes, next.
Seal number 14.
Yes.
Lordship, these 3 cases are connected and similar. We are, may I permit the withdrawing the 3 cases?
Oh, those are the matters.
Yeah.
With regard to
Yes.
Memo is filed?
A memo is filed.
A memo is filed seeking to withdraw the writ petitions, dismissed as withdrawn. Yes. Yes,
Please,
next,
ma'am.
15.
I'm for the petitioner in this case, my lord. My lord, in the present petition, my lord.
15, I have, Lord, appeared for all the respondents.
Yes.
My lord, the
They
present.
have
petition-
filed the wakalat.
Present petition is filed. My lord, the fact of the case is this, my lord, in the year 2019, my lord. The flood having been occurred in Krishna River, my lord, which
Requires the impugned order of approval for recovery of the excess amount of rupees
rupees 5,74,000, my lord.
from the relevant vehicle bills pertaining to the contractor.
Yes, which was adjusted, my lord. The bills having been cleared in the year 2020, my lord. In the year 2020, bills was cleared, my lord. My lord, there are, after due verification, only the bills.
Order? Where is
This
the order?
order is in Canada, my lord. At
Lord,
Annexure
this
D,
is
my
the
lord.
internal communication between,
That's why I'm asking where is the order?
yes,
Annexure D, my lord.
Page number,
Page number 81, my lord.
page number 81.
Please, my lord.
This is addressed by whom to whom?
My lord, it is. It is issued by the respondent number 4, my lord.
Respondent number 4 to whom?
My lord, there is no
No,
specific,
you
my
see,
lord.
you see that it is so and so. What it says, please read.
My lord, ಮೇಲಿನ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೆಜಾಸ್ ಜ್ಯೋತಿ ಎಲೆಕ್ಟ್ರಿಕಲ್ಸ್ ಕಾಗವಾಡ್ ಇವರು ಕಾಮಗಾರಿಯ ನಿರ್ವಹಿಸಿ ಸಲ್ಲಿಸಿದ ಬಿಲ್ಲಿನಲ್ಲಿ ಹೆಚ್ಚುವರಿಯಾಗಿ ಪಾವತಿಸಿದ ಮೊತ್ತ ರೂಪಾಯಿ 5,74,738 ರೂಪಾಯಿಗಳನ್ನು ಕಡಿತಗೊಳಿಸಿ ಪಾವತಿಸಲು ಮೇಲಿನ ಉಲ್ಲೇಖ 2ರ ನಿರ್ದೇಶನದಂತೆ ಸದರಿ ಮೊತ್ತವನ್ನು ಭರಣ ಮಾಡಿಕೊಳ್ಳಲು ಸೂಚಿಸಿದ ಪ್ರಯುಕ್ತ ಸದರಿ ಗುತ್ತಿಗೆದಾರ ಸಂಬಂಧಿಸಿದ ವಾಹನ ಬಿಲ್ಲುಗಳಲ್ಲಿ ಹೆಚ್ಚುವರಿ ಪಾವತಿಯಾದ ಮೊತ್ತ 5,74,738 ಕಡಿತಗೊಳಿಸಲು ಹಾಗೂ ಹಿಂದೆ ಜೆವಿ ಮೂಲಕ ದಾಖಲಿಸಲಾದ ಖರ್ಚು ವೆಚ್ಚ ಸ್ಥಗಿತ ಆಕರ್ಷಿಸಿದ ಸವಕಳಿ ಜೆವಿ ಮೂಲಕ ಹೊಂದಾಣಿಕೆ ಮಾಡಿಕೊಳ್ಳಲು ಈ ಮೂಲಕ ಅನುಮೋದಿಸಲಾಗಿದೆ. Has been approved by my lord for adjusting the bills, my lord, from the.
What is this?
no, Lord, he had carried out certain works, in which, Lord, he had claimed more amount what, Lord, actually the work which was carried out by him. Therefore, Lord, the higher authority, while, Lord,
These proceedings are by which authority? What is the name of the officer?
to adjust the bills
Who is the designation of the officer?
from superintendent engineer to the, Lord, executive engineer, the billing
Executive
authority.
engineer. Now, what the executive engineer will do?
No, he is-
Executive engineer will
he'll-
issue a notice to you,
Yes,
isn't it?
Please.
Will issue a notice to you, will
Please.
tell you what it is. How can you question this order, an internal correspondence which is not even issued to you, wherein they have not even asked you to pay?
My lord, already adjusted, my lord. Already the bills having been adjusted.
no, I
my
have to
lord.
seek instruction in that regard. But only
Without
thing
a
is,
notice to the party,
no,
how
no,
can you adjust the amount?
it will be all be, it will be done in the final bills. Unless until he signs to the final bills, that would not be
That's what
finalized.
my case, my lord.
That is
Without
what
considering
Lord-
without giving me an opportunity, my lord, my bills having been adjusted, my lord.
No, I'll seek instruction. Because yesterday, Lord, they have,
If it is adjusted, then the order needs to be set aside.
no,
That action has to be set aside.
because there appears to be, Lord, excess claim of the bill.
Then counsel of the petitioner submits that. The respondents have. Have adjusted an amount of rupees 5,74,738 from the petitioner's account,
Petitioner's vehicles bills, my lord.
from the
Petitioner's-
which you have to pay.
Yes.
Please.
How it is adjusted?
No, that's
Lord,
what
there are-
Lord, I need to seek instruction.
What is the procedure to adjust? How is it available? to-
Because, Lord, he is a contractor, he will
He's
be,
an existing contractor.
yes,
as
yes,
of-
Please,
he is an existing.
Has adjusted an amount of rupees 5,74,738 basing on the letter addressed by the superintendent engineer to the executive engineer. It is a case of the petitioner that no notice is given to the petitioner and no inquiry is conducted. Petitioner has not been given an opportunity. Land counsel appearing with the respondent submits that it is an internal correspondence between in the department and the petitioner cannot question the same. Next paragraph. The respondent shall get specific instructions whether the amounts are adjusted basing on this 5,74,738. Any opportunity of hearing is given to the petitioner or not. Objections, the petitioner shall get the instruction of the respondent by 24th of February, or else considering the submission of the land counsel for the petitioner, the writ petition has to be allowed, will be allowed.
Today I have filed Lord Wakalat for all the respondents.
So and so, but it will come, your name will come.
Srinivas, my name has to be shown.
It is submitted that so and so has filed wakalat for respondents number 1 to 4.
Yes.
Yes. Then this name to be
The
deleted. BS
earlier
Ram.
council name is to be
So and
deleted.
so name to be deleted. Yes, next.
Please.
Clean.
Seal number 16.
My lords, petitioners have filed a suit for declaration, permanent and mandatory injunction in the case OS 490 of 2016, pending on the file of Honorable Third Additional Civil Judge in
All
Belgavi.
those details are not required.
My lord,
What is the?
My lord, petitioners being aggrieved by the unnecessary delays in the legal proceedings in the said OS case. My lords, petitioners have filed I number 2 and 3 dated 27/4/2016. Even to this date, my lords, I number 2 and 3 have been remained.
Impugn order, let me read it. Where is it?
My lord, petitioners being aggrieved by the inordinate delay in adjudicating the original suit as well as I number 2 and 3, the
Suit of
petitioners
which year?
2016.
Mm.
Suit filed on 27/4/2016.
Mm.
And subsequently I number 2 and 3 have been filed on the 27/4/2016. Even both the IAs have. My lord, petitioner 1 is and
1 month. The additional instruction shall place before this court. What is the pendency? What is the oldest matter pending in this court? And in 2016, how many matters are pending? This is matter on tomorrow, get him telephonic instruction. Yes. 17.
7.
Please.
Yes.
Lordship says, small accommodation, my lord, I'll have some judgments I could not got. Lord, have it on next. Of course. Permission to file a written statement by withdrawing earlier, it is challenged by the plaintiffs.
Yes.
Sir, here. Yes. Please, I think I had informed his colleague, his duty as senior, that I'll seek some accommodation, my lord.
What accommodation you require? I'm not able to understand.
I want to, some citations, my lord, where?
What?
Lord, regarding this, this is a plaintiff's petition, my lord, where the defendants want to 10, my lord, here in file earlier written statement. Subsequently, they withdrawn it and now entirely, completely replaced itself, my lord. They has to do by their way of amendment or by modification itself. But
It was permitted to withdraw.
they say that earlier council has not filed anything, my lord. In fact, now earlier council have produced, my lord, may kindly see.
You did not object for it.
No, the fact, the earlier which was filed on, taken on record, and there was a change of council, my lord. And they,
This matter in the month of March. Take this.
next, my lord, just,
Not possible. March.
please.
Yes, next. Yes, 18.
My lord, challenging annexure D and E, my lord, the compromise decree, my lord. Lord, suit for partition separate position, my lord.
You are a
Respondent,
party to the suit?
my lord, my mother was the party, my lord.
Hmm.
My mother, suit was decreed, my lord. And they have filed FDP, my lord. In FDP, all the parties have compromised, my lord. In which my mother was the party as defendant number 2, she has signed the compromise decree, compromise petition, my lord. Later on, my lord, my mother died on 14/7/2023, my lord. 14/7/2023, my lord.
Hmm.
And meanwhile, my lord, the respondent number 1 to 5, my lord, have filed execution petition, my lord, before a trial court, my lord. And now the petitioners, my lord, petition number 1 and 2 are the legal heirs of defendant number 2, my lord, are trying to retain some of the properties in their name, my lord. In the compromise petition, my lord, they have all the parties have agreed that all the suit properties will be alienated, and they will share the sale consideration amount towards themselves as per the preliminary decree, my lord. But now, my lord, there is trust issues in between petitioner and respondents, my lord. And respondents are trying to alienate the suit property in a lower price compared to the market price, my lord.
But that can't be a reason to interfere with the compromise decree.
No, my lord, they are trying to alienate the suit property in a lower price, my lord.
Will be, no, compromise decree can only be set aside on limited grounds. The grounds which you are saying are not the grounds on which this court will interfere. If that is the case, then no compromise.
It is entered by the mother of the petitioners, my lord.
So you are the legal heirs. You have succeeded to the property of your mother.
Yes,
And all
ma'am.
you have said, that's the reason. We can't interfere.
My lord, petitioners are intending to keep the property with themselves, my lord.
You can't take,
they are
your
not,
mother has already entered into a compromise. That's binding on you.
Yes, my lord.
If this is the case, we entertain these petitions, then there is no end for the litigation. The present petition is filed.
My lord, at least notice me, we should, my lord. We will settle the matter, my lord. At least notice.
What kind of frivolous petitions are filed? Notice to the respondent.
My lord's request for short passover, my lord's counsel on record is held up before some other court. My lords.
I am part of the petitioner.
Yes. Password. This 20.
This is defendant court's writ petition. 2 applications are filed, my lords, for recalling and, my lords, for cross-examination of
Who
DW1.
appears with the respondent?
Kiwater, my lords, Mr. Sunil Desai.
Password.
Please,
After
I'll
if
inform.
he's not there also will pass
Please,
on.
I'll inform.
Yes, 21. Notice to R3 is required.
R3 was the complainant before the authority, my lords. I insist,
Petition.
lords, tender matter where I have completed the tender work way back in the year 2022. Subsequently, a complaint comes to be filed. 2024, Lokayukta conducts a spot inspection.
As per the tender.
Yes.
Any disputes with regard to the payment and all, is there no clause?
There is an arbitration clause.
Then why this court is looking into this?
What has happened is tender is complete. I have completed the tender work.
Tender is completed, money is not released.
The money is also released. Final bills were also paid. Subsequently, complaint comes to be filed. Lokayukta conducts an inquiry. They say that one component quantity was lesser in the road. Therefore, now the chief engineer has written a communication to the executive engineer asking to withhold 84 lakhs from my pending bills in another contract.
Your Lordship, as it is found in the complaint itself and prima facie, it is found that the work he has done
On a
is.
monetary transaction, what is this prima facie? You should give notice to him, you should conduct an inquiry. and there
Inquiry
should be
is,
something should be
order
done.
is passed to your Lordship for inquiry, conducting the inquiry, Your Lordship. Now, at page number.
How can you take that money? How can you withhold that money?
Inquiry is sought to be held against employees of the PWD, not against me. Lokayukta is holding
Page number
inquiry against
91,
them.
Your Lordship, where it is found that as work is.
Impugned order I filed translated copy on 5th February 2026. Page number 3.
Then counsel, the petitioner submits that without any notice to the petitioner and basing on the letter written by the Lokayukta, the order
government-
impugned is passed by the respondent.
Uh,
An amount of rupees 86,75,787. And they have already withheld.
No, they are yet to withhold in other pending bills.
it is submitted that no opportunity is given to the petitioner. Considering the learned counsel, the learned SCGP submits that. Prima facie, the complaint reveals about
Your Lordship, notice was served and he has filed.
the government
Your Lordship,
construction of the work.
notice was served, Your Lordship. He has submitted his objections
Lokaयुक्त
also.
served notice. Lokaयुक्त served a notice. I said you have conducted after 2 years, so and so components are not considered. In spite of that, government issues a letter saying that no, chief engineer has directed us to withhold amount, we are withholding amount.
It is submitted that. Now the work is completed in
2022.
2022, entire bills are paid and the petitioner is executing some other works. Now they are going to, in the light of this order, they are going to withhold 86,75,787. Considering the same, there shall be, there shall be direction to the respondents not to recover the amount pending, not recover the amount from the outstanding bills pending consideration of this writ petition. However, the respondents are at liberty to conduct any inquiry, in accordance with law if necessary. The SCGP shall file the respondent shall file the objection by the next date of hearing, list after 4 weeks.
My one submission, if I may make, even by way of inquiry, they cannot do it. They have to go to the court to recover.
Whatever it is, whatever they want to do, let them
Inquiry.
do.
Please,
It
oblige.
will not preclude not inquiry, it will not preclude the respondents from taking any steps in accordance with law.
Oblige.
Please, I appear for petitioner.
Admit to appear for the respondent. Madam, permitted to file not statement of objections.
Respondent number 2, my lord.
Madam, permitted to file statement of objections.
Have you served on her?
Yes, my lord.
Now they have served it.
So far as
What are these writ petitions about?
Please, my lord. The respondent number 2, my lord, page number 11, is the institution registered under the Karnataka Societies Registration Act, my lord.
Yes.
Now, the petitioners who are elected members has filed a writ petition seeking for quashing of the Annexure A. Annexure A, my lord, my renewal application is rejected by the respondent number 1.
In how many writ petitions you are appearing?
I appear in all the writ petitions, my lord, I appear for. Now I have filed a writ petition, 22, I am appearing for petitioner, 22.1 I appear for petitioner, and 22.2 I appear for respondent number 4, my lord. Then 22.3, my lord, I appear for respondent number 6, my lord, caveator, and 22.4, my lord, I appear for petitioner, and also I have challenged the impugned order.
Let's go with one after the other.
Please, my lord.
100839, where is the impugned order?
Impugned order is Annexure A, my lord, page number 24.
20?
24.
What is this order?
This is the order passed by the respondent number 1, Deputy Registrar of Cooperative Society, rejected my application for renewal of the renewal of the board of members. As per the bylaw, my lord, every 5 years election has to be conducted. Accordingly, my lord, the petitioners has followed the bylaws and also section 13 of the Karnataka Society.
What is the reason for
Rejection, reason is, my lord, already I have approved the elected members, my lord, that is questioned in the 22.5 in writ petition. I have questioned it, my lord. Therefore, my lord, and you have not filed an audit report, one reason, and you have not followed the procedure to conduct an election. On these 2 grounds, my lord, it is rejected. It is rejected. Your lordship, kindly come to section 13 of the act.
Yes. Yes.
Balance sheet and annual list of governing body to be filed with the registrar. That is respondent number 1.
Every year.
Yes, I filed it, my lord. In the in the 13(1), my lord, your lordship kindly consider on or before 14 day of succeeding the day on which the annual general meeting of a society held, there shall be filed with the register a list of the names. It is most important. List of the names, address and occupation of the members of the governing body. Please, my lord. Then, my lord, your lordship kindly come to proviso, first proviso, provided that if for any sufficient reason for a society has not filed the list of members of governing body and copy of balance sheet and income and expenditure account on or before 14 day of annual general body meeting of the society, it may make an application to the registrar to condone the delay and permit to file the records, and the registrar may, if he is satisfied that there are sufficient reasons for the delay in filing such records, condone the delay and permit the notice to file such records subject to payment of fine as may be prescribed, and no sufficient reasons are shown, he may, after giving an opportunity of being heard to the society, reject the application. Proviso says that they have to issue a notice, they have to provide for opportunity of hearing. In this case, my lord, there is no meeting and there is no providing for the hearing, my lord. Opportunity of hearing.
Where is the opportunity?
They have not issued a notice.
Where is the notice?
No, notice, no, they have not issued a notice. Please, my lord.
The provision, where is it says that you should be issued a notice?
Please, my lord. Your lordship kindly see. He may, after giving. He may, after giving an opportunity of being heard to the society.
It is on your application.
Yes, my lord.
They give you an opportunity. That's what it says.
Yes, my lord. He rejected my application. This is one thing, my lord. And also, my lord, your lordship kindly come to.
First of all, after how many years you have filed your statement of balance sheet and
Immediately, and also.
means when?
Please.
You have to file every year by that day.
Within 14 days. Within 14 days, we have to file it, my lord. Please, my lord. Your lordship kindly see, my election is declared on. 15/2/2023, my lord, calendar of events is issued. Sorry, sir. 25, my lord.
What 25?
6/9/2025, calendar of events is issued, fixing the date of election on 28/9/2025. I have submitted my application after conducting the election, my lord, that is Annexure B.
You can give that.
Annexure B on 9/10/2025.
Take up this matter in the afternoon. I think it will take some time. I'll complete the list.
Please, my lord.
The first matter, my lord, other matters, my lord, I filed a statement of objections. First matter, my lord, tomorrow, my lord, today evening, my lord, I will file statement of objection, my lord. It may be called on tomorrow, my lord. We will dispose of all the cases. My lord, I'll make one submission. Last occasion, my lord, the batch of cases, my lord, this writ petition listed before the court. Court directed the government advocate to find out whether section 25, the inquiry under section 25 is concluded or as ordered by the earlier order passed by this honorable court. The government advocate took a time to furnish whether 25 section inquiry is concluded or not.
Clear order.
Your lordship.
Yes, Annexure R2, my lord.
May I answer for this, my lord?
Get specific instructions. This is matters tomorrow.
Yes, my lord, on
But let them
22.1, my lord.
Let them not go.
Produce.
Please, my lord.
My lord, may I make one submission, my lord? 22.1, my lord, the same inquiry report is questioned before your lordship, and this honorable court granted an interim order.
Yes, tomorrow.
Already it is on record.
For 20.
Please, my lord.
And I want all the.
All the
gist of
cases,
events.
my lord, all the.
Yes, my lord.
I don't want any of you to take time and, prolong it. I want.
Yes, my lord.
Please, my lord.
Answer for everything.
Yes, my lord.
Yes,
But
ma'am.
only my lord's kind consideration is one group not claiming board of directors, another group claiming board of directors. Whether actual amount board of directors has to be decided by the competent authority.
Not
Who-
only board of directors.
You have to.
There is a
Please.
several interim order.
Yes.
This is the only point, my lord.
Please wait, let him
This-
say, when one ad council is appearing.
Yes.
Arguing, others should have the patience.
Please.
Yes. 1 minute.
Please.
Yes.
But earlier, my lord, in the 2021, a writ petition was filed, but petitioner as well as the respondent both have filed, my lord, the proposal under section 13. This honorable, the authority rejected their claim. Then this honorable court, my lord, they filed a writ petition. This honorable court said, both proposal has to be considered and pass, my lord, appropriate order as provided under section 13. After, my lord, remand, the authority passed an order accepting our proposal, holding that our committee is correct and accepted our report, and board of list of office bearers has been accepted. Once again, these petitions have filed a writ petition. In the writ petition, this honorable court found that inquiry is required to be held under section 25. Therefore, passed an order directing the authority to conduct an inquiry, but they have not conducted an inquiry. However, this honorable court directed the authority to pass fresh order under section 13. Once again, my lord, our proposal has been accepted. The respondent have filed once again writ petition. So this is how, my lord.
Horrible discourse.
That is stayed by this honorable court. And also there is a direction. He is not a Uttaradhikari. He is not a chairman. And it is to be finalized in the suit where he has filed a suit, my lord. And this election was held by the direction of this honorable court, my lord. And there is a direction to DRCS not to accept any papers filed by the respondent. Though there is a direction, my lord, now he is they are violated the order. We have filed a contempt against this also.
Yes.
Please.
Appear for the petition, Lord. Seeking not the core and to not the appear for emergent notice. Facts of the cases, all these petitions, not the board of directors have been superseded. Once they have superseded, the question of not participate in the election does not arise. But the election was held and they are declared as elected. But under section 20 subclause 2 B1, it provides that the persons. Please, ma'am.
Take notice for respondent 1 and 2.
1 and 2, HCGP takes notice. Yes, next. After, call the AAG. Where the preliminary hearing is ending. After 42, I will take up this matter.
Please.
Yes.
24 minutes.
Yes,
Serial
please.
number 24. I appear for the petitioner in this matter, Millets.
Yes.
Petitioner is Millet's third-party auction bidder, who Millets participated in the bid, and Millets deposited EMD of rupees 16,51,000. Subsequently, Millets, the original defaulters issued the notice after auction, stating that I was the only bidder and auction is vitiated and they are going to take action against me. They are challenged before the appropriate
When
authority.
did you pay this amount?
Millets, that is at Annexure C 24, Millets, 11/11/25.
11/11/25.
25. Please, Millets.
Now they have, what has happened to the sale? They have set aside.
Now, Millets, fourth, the auction was held. Subsequently, Millets, there is no reply from respondents. And I gave a representation stating that I do not want to participate and my EMD may be returned. Now, Millets, there is no forfeiture order or there is no communication. Now, bank proceeded with another auction that also I have produced at page number 31, Millets.
No.
My
Why you didn't want to proceed with the auction?
No, Millets, I was the only auction bidder. Then I requested the bank saying that I am the only bidder, return my amount, EMD, since the original defaulters, Millets, have issued the notice stating that, Millets, I'll be prolonged with the litigation.
Which is the
Because
bank?
of that fear.
Which is the bank? Canara Bank, who is the panel counsel? You appear? Huh? So and so is directed to take notice. Then counsel the petition serve the copy of the writ petition on the council. This is
One-
matter on 25th.
20. Please. Grateful, Your Lordship.
Number 26.
My Lord, I'm representing the husband petitioner before the Honorable Court. The petitioner is before this Honorable Court on the basis of the impugned order passed under Section 24 of the Hindu
How much
Marriage
is-
Act.
How much?
I'm
is
ready to. I'm ready to pay 3,000 each to the kids, my Lord. My humble
First of all,
submission,
tell
because
the court what is the amount that is granted by the court?
15,000, my Lord.
15,000 to
50,000, all the petitions, so petition number 1 and petition 1, 2, 3. Means
Wife and-
wife and kid, 2 kids,
2 children. What
2
is your
children, my
income?
Lord. I am right now I am unemployed, my Lord. Prior to that, I was an employee.
After the order is passed or before the order is passed?
No,
you
my
become
Lord, prior to, because of the personal disturbance, I got shifted from Pune due to the
Let's see the
personal,
order. Let's see the order. Where is
yes,
it?
yes, my Lord. Even on the basis of the assets and liabilities itself, learned trial court magistrate has passed the order.
Yes, let's
Yes,
see.
it is at paragraph, page commencing from 18th of my petitions, my Lord. And no doubt, at paragraph of the order, impugned order, page number 5, paragraph number 10, my Lord. The learned trial court magistrate mentions that his father income is 70,000. Neither in my assets and liabilities nor in the assets and liabilities filed by my respondent wife, no such contentions are made out.
The counsel for the petition submits that. As per the statement of assets and liabilities filed, he has no income. And the court, considering the fact that the father is a pensioner and his income is 70,000, has granted an amount of rupees 15,000. It is submitted that the court ought not to have granted such an amount. Considering the submission, there shall be stay of all further proceedings on the condition that he shall pay an amount of rupees 7,500 by 5th of every succeeding month.
Submission, my Lord. 6,000 we can leave fast.
Also at 7,500 within 8 weeks. If either of this is the petitioner fails to comply, the stay granted by this court stands vacated. Next, the petitioner shall take out hand summons on the council appearing for the respondent and shall file a memo to that effect by 25th of February. If the memo is not filed, even on that ground, the stay granted by this court stands vacated. Yes, next.
For petition, my Lord. Similar matters are pending before this court, my Lord, where this court, honorable court, as far as principal bench, my Lord, wherein this honorable court and principal are granted the stay of demand notice, my Lord, and directed respondent number 3 to allow the license for 2025-26. My Lord, it may go page number 126, my Lord, K2, annexure K2, similar order, my Lord.
Yes.
Please, Your Lordship. I'll take notice for
1, 2,
respondent
3
number
is-
1, 2.
Taking notice, you
Please,
have to
Your
read the order, whether it is covered or not, you have to tell the court.
That's, please, Your Lordship.
Please.
Yes.
Lords, may I seek a week's accommodation?
How many times the matter will be adjourned?
No, my Lords, it's the first time it is listed.
Earlier also some matters
No,
were passed.
no, my Lords.
Yesterday or
They are different, my Lords.
same matters as this
But they are different, my Lords. This is,
time after
my Lords,
filing it.
this is transgenerator matter. Next week I will argue, my Lords. Some preparation I have to do. With office objection, it got listed, my Lords. I was not aware also.
Externment under section 56, Your
The right
Lordship.
of appeal before the court
That's
will
all.
go there.
But without preparation, my Lords, it is listed. She is a transgenerator, my Lords.
This is matter on Monday, no further adjournment.
Tuesday, my Lords. Please.
Yes.
Number 29. What?
I comply the office objection within 2 days, my lordship. 2 days time is granted for.
Let's see, what is the writ petition? Then we will think about the
Please.
office objection.
Please.
Recreation club case, Your Lordship.
The petitioner is running a club and already is registered, but only for transfer one place to another place.
Directing not to insist upon the petition to obtain a license for playing skill games like chess, dart, rummy, carom, video games, so and so. Then what is happening?
This club is already registered, my lordship, but on the address is changed
Get instructions.
from one place to another place.
Comply with the office objections within 2 days. Failing which the writ petition shall stand dismissed. HCGP takes notice on behalf of respondents 1 to 5, 1 to 6.
1 to 6.
And shall get specific instructions. List this matter on 18th of February. Yes, yes.
The petitioner seeking to quash the imposition of 12% forest development tax, my lords.
Let's see.
Annexure B, my lord.
Where is the order?
Annexure B. My lord. Page number 10, my lord.
Dispose it off.
Please, Your
Cover.
Lordship, FDT
Please.
last, yesterday.
The present writ petition is filed seeking the following prayer. It is a case of the petitioner that he is engaged in the business work at his is engaged in the business and participated in the public e-tender cum auction of the timber and firewood in Halyal, which has already been sold through a public e-tender cum auction notification issued with respondent number 2 authority. It is the case of the petitioner that is surprised to see that the respondent number 3 authority has levied forest development tax to an extent of 12% on the wood purchased by the petitioner. Agreed thereby, the petitioner is before this court. It is submitted that then the similar orders you have taken. Somebody must have taken. The remaining the position, writ appeal and all you can write. Give him that. Yes. Yes. Next, 31.
Notice, Your Lordship, I'll take,
So and so takes notice.
please.
That is also a covered order, part of order.
31, my lord, I represent the petitioner. The respondent number
Your
2
Lordship,
is
this
the,
matter is also pertaining to serial number 10, Your Lordship.
Serial number 10.
10, Your Lordship, which is passed over.
Number 10.
Passed over, Your Lordship. They were good, that same temple,
Here-
Your Lordship.
here the grievance of petitioner is appointment of trustees for category 2.
I will be taking after the preliminary hearing that after
They
along
were
with those matters.
They were good. Serial number 10 it is passed over.
After preliminary hearing till 42, after 42 I will take up those matters.
I don't know what is that, but
That's why you will be here and you can argue. Yes. Ask the AG to come by the time.
Please, Your Lordship.
Yes, next. Tell the advocate for the petitioner also to be here.
Please, Your Lordship.
Yes, 32.
Please. Lord, the petitioners are the defendant in a suit for specific contract filed with respondent number 1 herein. The court below, my lord, after service of notice, has not taken written statement filed after 120 days, my lord. It has rejected my proposed WS, my lord.
When were the notices?
Yes, my lord, prior to it, my lord, may kindly see the order sheet. They did not,
Tell me the dates, that's sufficient.
yes, ma'am. My lord, the suit summons were served to me on 29/8/2025, my lord. Thereafter, on 16/10/25, trial court directed the plaintiff to furnish the plain documents, suit documents, my lord. And they furnished it on 24/11, my lord. And I filed the proposed written statement, my lord, itself on the 13/1, my lord. So that would be 55 days just, my lord, when suits documents were given to me, my lord. It was well,
Amendment speaks about what?
please,
The amendment for filing the written statement.
not
speaks
amendment, my
about-
lord, the initial, the suit.
Amendment is the act amendment I am referring to.
It says, it is not mandatory, my lord. Salem Advocates Association, 2005 itself, long back itself.
Latest amendment to the CPC 2025 amendment.
That is for commercial suit, my lord.
Huh?
That is for commercial courts, my lord. This is ordinary civil suit.
No, no, no.
Yes.
That is not for commercial suit.
Yes, ma'am. The
Amendment to the CPC.
no, that is there, my lord, amendment, but
What I am asking, as per the amendment, what it says about 120 days time it is referring to.
Yes.
That is from when?
when the first service of the suit summons, my lord. Yes, ma'am.
So where is the scope for interpretation?
No, here, my lord, they on 24/11/2025, they served the document.
Notice to the respondent.
My lord, now the suit is posted, the defendant number 1 has colluded and filed written statement admitting the plaint contents, and suit is for specific performance, my lord. We are the deceased, we are the LRs of the deceased.
Petition is permitted to take out hand summons on the counsel for the respondent and file a memo to that effect. once the memo is filed.
My lord, may kindly say, because today matter is posted to the evidence of the plaintiff, my lord. Already defendant number one has admitted the plaint. I have filed the written statement. Defendant number one admitted the plaint and suit is for specific performance.
Amendment is mandatory in nature.
No, no, in case of my lord, commercial suit, it is not a commercial
You
suit.
get that, that you please place the amendment before the court and tell the court.
Yes, even that only for a moment, my lord, kindly see the order sheet. When they served is 24/11, my lord. I filed it
What I
on
asked
30.
you, does the amendment speaks about from the day the papers are served on the plaintiff defendant?
No,
It doesn't say so.
No, unless my lord, the plaint suit documents are given, I can't file the WS. And very first, my lord, the kindly see for a moment, my lord, page 38, my lord. For a moment, may kindly see. Your lordship, the order sheet speaks itself, my lord. And it is a suit of 2025 itself, my lord. Your lordship may kindly see page 38, my lord.
No, if first of all, you have to tell the court that the amendment doesn't apply to the.
Yes, my lord.
That you tell the court, I will hear you. Tomorrow I'll hear.
Yes.
Yes, tomorrow.
Yes.
Three office objections raised on the writ petition. Lords, office objection number.
What is, I can argue, what is the writ petition about?
Lords, court in a money recovery suit, court commissioner was appointed to verify the disputed and admitted signature of the defendant. That was allowed and sent to the RFSL. RFSL submitted a report saying that the signatures are outcome of forgery. Then I am the plaintiff. I have relied on those documents. Then we filed an objection saying that your lordships will get objections at page 139. There are certain discrepancies which the court commissioner ought to have taken into consideration, etc. After filing of the objection, lords, without even affording an opportunity to cross-examine the court commissioner, objections have been rejected and court commissioner report has been accepted.
Did you seek for cross-examination?
Objections was filed. Objections to the
You
court.
should ask her that if you want to cross-examine, why the court will visualize that you want it? It's nothing but dragging on the proceedings, and when the result is against you, you are coming up with that's what we have to assume.
Because page 140 objections, if your lordships may kindly see, once objections are filed, opportunity has to be afforded to cross-examine. Otherwise, if I admit the commissioner report, question is different. Lords, now it is posted for arguments, my lords. Let at least judgment not be passed subject to the.
The petitioner shall take out hand summons and file a memo to that effect. Once you file, I will hear.
May I
And
seek?
if the memo is filed, immediately all these matters, wherever I said the memo shall be filed, list the matters immediately after the memo is filed.
Please, oblige.
The CPC matters. Yes. Yes. Who's that? So what is this?
Your Lordship, they are seeking for a prayer at page number 8, Your Lordship. Madam is to release the petitioner on parole till the premature,
Take a decision,
as he has completed 14 years.
to take a decision on the recommendation as per the government order dated
14 years.
21/4/2020. What is this 21/4/2020 order?
It is at page number 45, Your Lordship, and annexure B,
What is this?
wherein government has passed.
To the government of Karnataka, issuance of guidelines to consider.
Please, Your Lordship,
Premature
in this
release of
case, Your Lordship, the offense punishable under section 302 is there, Your Lordship. And he has completed, as per the contention, Your Lordship, he has completed the imprisonment for 12 years, Your Lordship. On that ground, they are seeking for parole, Your Lordship.
He seeks as per this proceedings of the government of Karnataka.
Karnataka.
If he is entitled, you give him. If he is not entitled, tell that he is
I
not
will
entitled.
verify whether he has completed, how many years he has completed, Your Lordship.
Why should we do that exercise? Let your officers do it.
Please, Your
If
Lordship.
he is entitled for anything,
Please, Your
basing on his representation, consider. If he is not, you reject it.
Please, Your Lordship.
The present writ petition is filed, seeking the following prayer. There is no representation on behalf of the petitioner. Next paragraph. No, before that, you write the facts, then it is a case of the petitioner that is convicted for the offense punishable under section 302, 201, read with 34 of IPC and section 30 of the Arms Act. And the same, the charge sheet is filed and is numbered as SC number 378 of 2011. He was convicted in SC number 378 of 2021 under section 302, 201, read with 34 IPC and section 13 of the Arms Act. Then the petition has questioned the same by filing criminal appeal number 2582 of 2013, and the same was dismissed on 17/11/2015. It is a case of the petitioner that the state of Karnataka has issued a guidelines to consider cases of premature release of live convicts seeking serving sentence in the prison established in the state of Karnataka by government order dated 21/4/2020. It is a case that earlier petition has filed WP number 106068 of 2025 to grant parole for a period of 60 days. And the same was allowed. According to the petitioner, that he has completed 14 years and 8 months of detention, including remission. And the authorities are not considering the case of the petitioner in the light of the government order dated, the government circular dated, where is that?
21/4/2020, Your Lordship, page number 46. Page number 46, Your Lordship. It starts from 45, Your Lordship.
Dated
21/4/2020.
21/4?
2020.
21/4/2020. Then counsel, then an SCGP appearing for the respondent submits that she'll get instructions. It is the case of the petitioner that he is entitled for the benefit under the as per the proceedings of the government of Karnataka dated 21/4/2020. If that's the case, the petitioner, the respondents ought to have considered the case of the petitioner. And the other orders that are passed by this court, that as is entitled for the parole, he is entitled for the remission as per the order dated 20, as per the proceedings dated 21/4/2020. That itself cannot be a ground for this court to grant parole to the accused. If the accused requires a parole, the procedure that has to be followed is as per Rule 191 of the what is that, Karnataka Police
Manual.
Prison manual, that is.
Prison manual. Prison manual.
As per the prison manual. Hence, this court cannot pass such an order. Pass an order. Accordingly, this court is passing the following order. Which respondent shall consider this?
Respondent number 3, Your Lordship. 3 and 4, Your Lordship.
The respondents number 3 and 4 shall consider the case of the petitioner as per the proceedings of the government of Karnataka dated 21/4/2020. And this exercise shall be completed within a period of 2 months from the date of receipt of the copy of the order. Somewhere you read, there is no representation on behalf of the counsel on behalf of the petitioner. It's CVP for all respondents. Yes.
Seal number 36, J. Narasimhan.
The petitioner questioning the imposition of 12% forest development tax.
Yes, same.
Please.
Like earlier. Yes, disposed of.
37.
37 also same?
Please.
Yes, 37.
Please.
Next 38.
Seal number 38. 38.
Give that.
Tirupati Prasad.
Petitioner herein, Your Lordship, is challenging the compromise decree passed by the Lok Adalat, Your Lordship. The facts of the case, my lords, that plaintiff, that is the respondent number 1, had filed a suit for specific performance against the original owner, who is the defendant number 1, and the present petitioner. Present petitioner is the subsequent purchaser, Your Lordship. But thereafter, my lords, during the pendency of the suit, the present petitioner has executed general power of attorney in favor of the original defendant, original owner, defendant number 1, my lords. wherein the interest of the petitioner has not been protected by the parties. Collusively, a plaintiff and original owner, defendant number 1, has entered into an compromise without protecting the interest of the petitioner, Your Lordship. That the terms of the compromise are,
GPA given.
please, Your Lordship,
What is the GPA given to D1?
to enter into an compromise and to look after the suit, look after the case, my lords. The only grievance of the petitioner is that there is no objection to enter into an compromise, my lords. However, this plaintiff is the registered sell deed holder. There is no clause or terms with regard to refund of the earnest money paid by the present plaintiff. Your lordship may kindly see the suit schedule.
Why did you give that kind of a GPA to a person and now you say that that is
It is
because he has a GPA, court has passed a compromise decree.
My lords, the interest has not been protected. It is told to the petitioner that as there was a common counsel for the defendant number 1 and 2, the present plaintiff, my interest will be protected.
Notice to the respondent.
My lords, the execution has been filed and now the matter, already the cell draft.
The compromise entered.
Please, your lordship. The 16/3/2024, the compromise decree has been passed by the Lok Adalat.
What are you doing till now without questioning it?
Your lordship, I got the knowledge of the present compromise only after receiving the notice in the execution petition, your lordship. The execution, now the matter is posted, already the cell draft is given by the court commissioner.
Paul, the grounds which you say are not the grounds to set aside a compromise decree.
My
You
lords,
give your eyes wide open. You give a GPA to somebody, you compromise the matter.
my lords, it was been told in that in a fiduciary relationship will
Ultimately, in a suit for specific performance, what would be the order according to you?
My lords, my intention was to refund of the earnest money, or there is one more clause, your lordship, that the present plaintiff is executed a registered agreement of sale with regard to 1 acre 20 guntas. I am the purchaser of 3 acre 20 guntas, entire property of the owner. There is no clause with regard to what happens to the remaining property, your lordship. Only clause is that the sale deed executed by owner.
Counsel appearing for the petitioner submits there is a collusive decree obtained by the respondents, and basing on that, now the execution is filed. There is a fraud paid on the petitioner. Hence, there shall be stay of all further proceedings pursuant to the judgment and the compromise decree dated so and so. Notice to the respondent, petitioner shall take out hand summons on all the respondents, hand summons on the counsel appearing to the respondent, and shall file a memo to that effect by 3rd of March. If the memo is not filed, the stay granted by this court stands vacated. Yes, 39.
Obliged. 39. Manjunath Bharat.
In the mandamus, Your Lordship. The de facto complaint filed the complaint against me, Your Lordship, colluding with the local police.
Direct the respondent police to forthwith
Please, Your
refund
Lordship.
amount of rupees 1 lakh.
Please, Your Lordship. And also seized the passport and check, Your Lordship.
No, Your Lordship, in this matter, the now first prayer, Your Lordship, insofar as first prayer directing respondent police not to harass or intimate insofar as FIR is concerned, Your Lordship. Now investigation is completed and charge sheet has been filed, Your Lordship. CC number 151 of 26 is there. 151 of 26, Your Lordship.
Lordship,
Then
without
question
any
of,
court order, enter the residence of the petitioner, seized the passport, Your Lordship, passports and one leaf of the check.
Private complaint against that police officer who did it.
Please, Your
Then,
Lordship. Now there is urgency in passport, Your Lordship. Kindly direct the.
Now, the
CC
the matter is pending before the court.
Please, Will.
Go before the court and file this application. Court will do it. The present writ petition is filed, seeking the following prayer. It is a case of the petitioner that the petition is arraigned as an accused in time number 76 of 2025. Registered with the Cyber Cell Police Station, Hubli, Dharwad, dated 4/7/2025. He has questioned the same before this court by filing a quash petition, and the same is pending consideration. After registration of the FIR, instead of conducting the investigation, the police officials began summoning the petitioner repeatedly through oral directions without issuing any written notice. They openly pressurized the petitioner to enter into a settlement with a de facto complainant. Further, Fourth respondent intimidated the petitioner to pay 1 lakh towards his office. What is this towards his office? What does it mean?
Lordship.
Petitioner to pay 1,000 towards his office. What is that?
1 lakh rupees. Your
1
Lordship.
lakh
I
towards
pay,
office.
I pay the 1 lakh rupees in
What
cash
is that
mode. Your
towards
Lordship.
office means what?
For due to the threat and harassing the petitioner only reason, Your Lordship. I pay in cash mode. Your
It is
Lordship.
the petitioner to pay an amount of rupees 1 lakh. And one Mr. Rakesh has been introduced to collect the amount. And it's a case of the petitioner that they went into the house of the petitioner without following the procedure, without the assistance of any women police. Where do you say about your passport? And according to him, the police have also seized the passport. Hence, he has come up before this court, seeking the prayers before Supra. Learned CGP's officer. The police have conducted the investigation and filed the charge sheet, that is CC 151 of 2026. 2026 on the file of.
I will give you, Lordship, a civil judge.
Give it to the court officer. On the file of so and so, it is submitted that petition has any grievance, the same can be addressed before the very same court. Expert, having heard the counsels on either side, there is a material on record. The kind of allegations that are placed before the court, those are all disputed questions of fact, which this court under 226 cannot decide the same. If the police officer has behaved in a manner without any authority of law, the petition has a remedy to file a petition against the concern for the magistrate. That apart, the charge sheet is filed. And if the police, even these aspects of the passport and other things can be brought to the notice of the court, or in the petition that's filed against the police, the petitioner can seek the relief, where the court will be able to decide all these questions based on evidence. And the relief has paid for by the petitioner. This court cannot grant exercising the jurisdiction on 226 of the Constitution of India. Accordingly, this court is passing the following order: that a petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy.
Lordship, one submission, Your Lordship. Kindly direct the police to hand over the passport, Your Lordship.
Are they accepting that the passport is with them?
Yes.
Yes.
Till number 40.
Yes.
Plaintiff's writ petition. In a suit for declaration and injunction, defendant files application for amendment of written statement after completion of plaintiff's evidence, and the matter was posted for defendant evidence. That has been allowed only. Yes, impugned order, Lordships will get it, page number. I'm sorry, I'm not. It starts from annexure G, my lords, page number, internal page number 6. Only reason assigned is that it will not change the nature of the suit.
What is the amendment that is sought now?
Lordships will get the amendment up. They want to include that there are 2 more daughters of myself who are required to be made parties to the suit. One. Secondly, that there are 2 properties which I have already sold. That is the only amendment which they seek to.
What is going to happen now?
My submission is, my lords, no due diligence, nothing. Amendment that after completion of plaintiff's evidence. If this was there on record, question would have been altogether different. I would have led evidence. My lords, if I may request, my lords, if they lead evidence based on this, my lords, entire.
Civil court in 1 week, all these matters won't be disposed of. The petition is permitted to take out hand summons, and the counsel appearing for the respondent and shall file a memo to that effect by 23rd of February. If the memo is filed, this is matter on 24th.
Please.
Yes.
Seal number 41. Irshad, what?
Petitioner is an advocate seeking a writ of mandamus. This is in respect of the ensuing elections to the Karnataka State Bar Council. In the COP and all the information furnished by the petitioner, place of practice is shown as Jamkhandi. However, in the voters list, it is at the place called Bagalkot. She addressed emails, my lord, requesting for change of place of voting from Bagalkot to Jamkhandi. Those are unanswered, my lord. So therefore, my lord, petition is before this honorable court.
Why it should be done? Place of voting from Bagalkot to
Yes, my lords may kindly see, my lord. Page number.
Which bar he is?
She is, my lord, since beginning practicing at Jamkhandi. Her COP information says she is practicing.
It is mentioned as Bagalkot.
That's what, my lord. It's only a mistake. That's why page number 12, my lord, annexure C.
Who is the counsel appearing for
Archana Magdum for respond number 1, KSPC, my lords. Respond number 2, my lord, I don't think, my lord, there is a panel advocate. It's the returning officer.
One we will ask.
One, my lord.
So and so is right to take notice in the name of the council. This is matter day after.
Please, my lord. It may be in the preliminary hearing list only, my lord.
Yes.
Please.
Yes, next.
42. 42.
Yes. Yes, Mr. Kam.
But I appeal the petition. Lord, the petitioner, Lord, marketing committee, Lord, has called in question the order passed by the labor commissioner, Lord, under the payment of gratuity act.
What is the order passed?
Lord,
What is the order passed?
Lord, order is passed, Lord, directing the petitioner herein, Lord, to pay the amount of rupees 26,296, Lord, with 10% interest. Lord. Admittedly, my lord, the husband of the petitioner, Lord, it is contended that, Lord, he was working in the marketing committee right from 1985 to 2005, Lord. But there are no documents, Lord, produced to show that, Lord, he was an employee of the marketing committee. But as an
See that order.
yes, Lord, annexure C, my lord. Ink page relevant portion starts from ink page 19, Lord. The reasons assigned by the court.
This is in Kannada.
Lord?
Order is in Kannada.
Yeah. Yes, please, ma'am. Please. I'm sorry.
File the translated copy. This is matter on Monday.
But meantime, I'll take out notice, my lord, to be responded.
The petition is permitted to take out hand summons to the respondent and file a memo to that effect in addition to notice. Yes.
Please.
The vice versa. Notice in addition. Pass over.
Pass over matter serial number 10.
I'm sorry, I was not present.
No, we will take up first WP 104279.
4279, first matter.
Yes.
Dharwad temple is notified temple not under the BPT Act. Earlier it was registered under the BPT Act. Later on, that BPT Act was struck down by the Honorable Court. And Hindu religious and institutions and charitable endowments act came into force of 2002. Plus, under this act, the temple is notified. I have no objection for that. Temple is notified under the new act. Later on, this Hindu religious institution and charitable endowments act was struck down by this Honorable Court only, as held to be unconstitutional. That went up to Supreme Court. Supreme Court initially, my lords, passed an order granting interim stay, and my lords, later on it is modified. Interim order dated so and so is vacated insofar as section 25 is concerned. Most rest of the act is stayed by the Supreme Court.
Section 25 is stayed.
Yes, ma'am.
Remaining other
Most are not in operation now.
What
It
is
was struck down.
25 is appointment of the trustees.
Yes, ma'am. Appointment of the committee, managing committee is the most section 25. Because the moment act came into force, the government has taken over all the institutions and notified the temples.
Constitution of Committee of
Yes.
Management. Now it is state.
It is now no. As far as 25 is vacated.
25?
Is vacated. As far as 25 is concerned, no, is vacated.
So which are the provisions that are questioned before the Supreme Court?
The entire act was challenged.
So no, the entire act is not in force.
Not in force.
It is in
Only
force.
20. No, I'll come to that. I'll come to that. I'll come to that.
It is in force. It is in force except
few provisions of the law.
What are those provisions?
I will produce the orders, enter orders.
Plus, first, Lordship can turn to page 30, my lord. This is the order. This is, sorry, page 29.
Page 29.
29. This is the first order passed. Interim stay in the meanwhile.
This is 2/4/2007.
Yes, ma'am.
From that day,
The act is in operation. Act is in operation except in respect of appointment of the hereditary archakas and all those. Instead of that, if my learned friend is arguing all those points relating to the validity of the acts, may request you stand up. No. If it is a contention that
What is the consequences of these orders? I'll narrate plus.
if it is my learned friend is not disputing. No, 1 second.
this order at page 31
Yes,
says, our interim order dated is modified to the extent that no adverse punitive action shall be taken with regard to the retirement age of archakas
Please.
and indoor temple servants till further orders of this court.
Please. Only in respect of that, there is a stay. Apart from that,
Page 29, interim order, my lord, sir.
Let's see what is the
Interim stay
interim
of the,
order.
in the meanwhile. Page 29.
Interim stay in the,
Meanwhile.
Where
And
is
next, my lords, next page is page 31.
no, the entire act can't be unconstitutional. Some provisions of it must be unconstitutional. What is that question? Before
Plus, entire act was challenged.
Where is that petition? Because
That is,
Supreme Court will not stay the entire act from 2007.
it is stayed, my lords, now.
Yeah.
It is even amendment, my lords, amendment brought to
It is
the,
true.
this act.
Initially, entire act was struck down by this honorable court, except in respect of the appointment age of archakas, in respect of other provisions of the consent, act is in operation. That's factual statement, madam.
No,
This honorable court
has
set
struck
aside
down
the entire act.
That what did you do when the entire
That
act is struck down?
Against that, we stayed prepared in SLP, my lord. SLP, there is a stay order, except insofar as the age of the archakas is concerned. In respect of other provisions of the act is concerned, there is the provisions is operating. Subsequently, my lord, again, there is an amendment. That amendment act is also been struck down by this honorable court. Against that, SLP has been prepared. In SLP also, there is a stay for the amendment also, amendment act
The
also.
order which is struck down is stayed by
It is stayed by the honorable Supreme Court. Now, except in respect of the appointment of age of the archakas, other provisions of the act as in today is operating. That is my statement.
Plus, page 33. Again, it was modified, my lords.
We're saying something about section 25 is.
25. My lords, kindly turn to page 33.
30?
33.
Yes. 39 is
33, my lords.
30?
33. 33.
Uh,
Again, it was interim order was modified.
hmm.
Interim order dated 2/4/2007 is vacated insofar as section 25 of the act is concerned. Your Lordship got it, no? This order was passed because
Look at, read paragraph, page 35.
35 months, yes. Interim order, plus here, the amendment was challenged. Amendment to this act was challenged before this Honorable Court, it was struck down. Again, it was challenged before Supreme Court. That order was challenged before. While dealing with amendment of the act, this order came to court, the page 35.
So, section 25 is in.
Is in operation.
Not in, is
It is in operation. I'll produce.
No, that you cannot say. You have to say from the order of the Supreme Court.
All the orders I will produce. I will request if that is the argument of my learned friend, have it. No.
It is a primary argument. Let him
No.
not say.
No.
you
I will produce all the synopses relating to the validity of this act. Have it on tomorrow, 2:30. No, there is no stay order, madam. That I will produce all the judgment from the starting judgment of this passed by this honorable court till today, madam. Till today, I will
This
produce the
interim
entire
order
order.
was modified because under section 25,
I have seen the acts like which is in parametria with these provisions. All of them were upheld by the Honorable Apex Court. And it is
Except-
operated that on the Hindu Charitable Institution and Endowment
no,
Act.
they are basically. it
Otherwise,
was
madam,
argued,
till today in all these in
there is
Karnataka, madam,
discrimination.
all the temples are run by the management committees only. It is renewed. All the Jilla Dharmika Parishad. It is run, madam. It is no. Factually,
Not there, how will it run?
no. It is today also, madam. There is no stay for the appointment of the committee is concerned. Stay operating only in respect of the age of the archakas is concerned. I will produce the retirement. That is in dispute. Except that, madam, all the provisions are operating. I will produce the with synopsis with list of dates. All these along with the the relevant orders of the Honorable Supreme Court, my lord.
If that is the case, my lord, the district judge has no authority to support
Yes,
the
yes,
committee.
this is altogether different. This is the case is that, my lord, here it is a scheme was framed under the old act. Subsequently, Karnataka Act came into force. Under the Karnataka Act, this temple was notified. In the view of the notification of the temple, the scheme framed under the old provisions will not going to be operated.
Be a provision with regard to that also.
Those will be, yes, ma'am. Those temples also be covered under this center. Under the.
Please place all that.
Please, day after tomorrow, 2:30, ma'am. Day after tomorrow,
Day after tomorrow is Thursday.
at 2:30, ma'am.
Thursday, 2:30.
Please, please.
Take this. Please take.
Please.
Mine is serial number 31, my lord.
Huh?
Mine is
What
serial
about
number
this?
31. My contention is regarding appointment of trustees in the present in respect of category 2 is concerned. On the ground that they are not qualified. Please.
There is no power to them to
No,
appoint.
they are not qualified. They will not satisfy the conditions for appointment under category 2. There
So
should be.
now, in the light of these submissions.
Yes, I know it.
When they themselves have no authority under section, and section 25 is stayed by the apex court, they cannot appoint them.
No,
But
here
it is
it
going
is
on.
appoint-
Huh?
But presently the appointment is made, they are working as trustees, they are functioning as trustees.
How they are not, how they are
For
not.
the
cooperating?
category 2, my lord, page annexure A, under the scheme, my lord, category 2 refers to, he shall further nominate 2 panchas from among the persons who endowed the property to deity, either in cash or in kind. There should be nothing but a donors
The
specifically.
respondents 1 to 2, HCGP takes notice, issue notice to other respondents. Next, by day after tomorrow, get instructions. The respondent shall get specific instructions.
Till then, my lord, they should not function, they are not
3 days,
qualified.
day
That
after
is,
tomorrow, yes. Yes, next. Forty-three.
Please. Orders matters. 43.
Why you are not taken paper publication?
My lord, now is the correct address in found, my lord, in West Bengal, in Kolkata is there, my lord.
What happened to the?
As per the, no, my lord. That, I will take the.
What happened to the?
Please.
Mic. Where is it kept? Yes.
My lord, I'm taken paper publications, my lord, as per R4, my lord, in the Sandur Taluk in Ballard district is there, my lord. But actually policy is there insured with the issued from the Kolkata is there, my lord, Kolkata. The insured insured is Kolkata, my lord. We take the proper correct address, my lord. Therefore, I am not taken, my lord. And also needful done, my lord, to already take out the notice is there.
You don't want to take paper obligation?
Not necessary, my lord. The correct address, my lord, is there, Kolkata is there, my lord, and also the company is there, my lord, actually. But in R4, my lord, JP Yadav.
Then counsel with the petition
Please.
subject, they could they could obtain the correct address of the respondent number.
4, my lord.
Respondent number 4.
4 is the
Hence-
issue.
Hence, they may permitted, now they have paid the process.
Please, ma'am.
Notice may be sent to the respondent.
Please, ma'am.
Accordingly, the list is matter after service of notice. Yes,
Please.
next.
Yes, thank you.
Yes.
44, adjourned serial number 45. Ravi's Balikai, Rishi Dharwad. Steps.
IA is filed today. IA for impleading, my lord, the correct person.
Submitted that today the IA is filed this matter after 1 week. Yes, 46.
46.
Yes.
Pray for 1 week to take steps for respondent, private parties.
What happened?
4 and 5, my lord, I have to take steps to the respondents 4 and 5.
Petition shall take out hand summons on the counsel appearing before the trial.
And summons, trial court execution has already been closed.
Nothing is said.
Nothing. But the amount that has been withdrawn, and now they have to redeposit before the court. Notice has to be issued.
No, the process shall be paid
Please.
within a week, or
Please.
else the writ petition shall stand dismissed against respondent.
4 and 5.
4 and 5.
Please.
47.
Please.
47. Arunal Nilopan.
For petitioner, my lord. A short accommodation, my lord.
10 days time is.
This is the respondent number 2.
And granted to bring the LRs on record, or else the default order.
Interim order on the extent. Interim order extent.
In all this interim order will be extended. Look at it.
Please.
Yes, 48.
Number 48. Govinda D party.
I'm proxy counsel for petitioner lordship. Kindly next week, counsel and record is out of station.
What is this acceptance of fan summons? Look at it.
They have already produced a memo, your lordship.
Let's see. Then counsel filed a memo that as per the order passed by this court, they have served the hand summons, but he has not mentioned the name of the advocates on whom he has served. A memo shall be filed clearly mentioning who are the advocates on whom he has served the hand summons. Yes, 49.
Number 49. Pachapure.
Respond number 6 has refused a notice not.
Notice to R6 returned as refused amounts to deemed service of notice. Yes.
Let's see, memo is filed, not, we have served the copy to the plaintiff's advocate and memo is filed along with acknowledgement.
Who is R6?
R6 is also one of the plaintiff, my lord. All the respondents are plaintiff, my lord.
Only R6 is to be served now. Others are served. R1 to R5 are already served.
R1 to R5, my lord, we have the served the copy to the advocates.
Also causeless reach so.
R6, my lord, he has refused, my lord, notice.
That's why I passed an order saying that it amounts to deemed service of notice.
Please, please, my lord, please.
Yes, let this matter after 2 weeks.
Please.
Yes, next.
Still number 50.
A list of the service of notice. Then what about R3?
Sir, will
Number 50.
No, not after service. A week's time for furnishing the PF in respect of service of notice to R3 or else default order. Yes.
Still number 51.
Yes. 52.
52. Heading on IA. Still number 52. Shant is customary.
52, my lords, the impugned order is in Kannada. But I had prepared one, my lords, but there's a lot of mistakes in that. Have it on Monday or Tuesday, my lords, within that time. Please.
At the request of land counsel for the appellant for filing the translated copy of the impugned order. Yes, 53.
Still number 53.
My lords, it's a case of death. There's a.
Yeah, I have undertaken to appear for the respondent insurance company on the last date of hearing. I'm told that they have sent the Wakalatnama. I will file the Wakalatnama tomorrow or day after tomorrow. And leave it on next week.
Yes, this is matter next week.
My lords, one date may be given, my lords. It's a case of death.
Respondent, this is a matter on 24th of February.
Please, my
Yes,
lords.
55, 54.
54.
Last occasion, Lordship used to hear this matter, directed the petitioner to produce documents. They have obtained this status quo order. Now they are interfering with.
Pass over. If they they don't open, I'll pass orders in the afternoon.
Oblige.
Yes, 55.
55. 55. L. Sandrimani.
No
Mantesh
representation.
Patil.
No representation. This is matter after 4 weeks.
2 weeks.
4 weeks.
Sorry, 4 weeks.
56.
56.
56, my lord.
This case will also undertake to appear on behalf of respondent number 3.
It's on behalf of the insurance company. I number 1025 is filed to condone the delay of 56 days. Where is this proof of deposit not filed?
I am told that we have already deposited the
The I number
amount in
1025 is
compliance of
filed to
the.
condone the delay of 56 days condoned. Then counsel appearing for the appellant's office that the amount is already deposited. Admit final hearing. Call for the DCR. Is 57.
Please.
57. 57. Sharad P. AGA. Sadiq Kanvi.
My lords, I appear for the petitioner, my lords. Your lordships had asked a doubt, my lords, regarding the same matter, wherein I had filed an IA for amendment, my lords. Your lordships had asked a doubt, my lords, regarding that there is already a miscellaneous petition filed in 2018. Why have you not brought due diligence? With respect to that doubt, my lords, that miscellaneous petition was filed by us, my lords, well and truly, my lords. But in that Shahzad Begum, who is respondent number 2 and 1 and 2 herein, were not made a party, my lords. Our earlier allegation was against the government and also against the Kumbarwada Masjid, and we didn't know that the Collusion.
After lunch, we'll hear this.
Yes, my lords.
57, yes, next.
Please.
Please, my lords.
58.
58. Seal number 58.
This also, after 4 weeks, no representation on behalf of other parties.
Ravichandra R. Patil, Mrutyunjay Tata Bangi.
Which one?
58. 58.
Is 58 pass over, 59?
58 pass over. Number 59. Ajay Baddi.
Appear for respondent. This my lord challenge the order, my lord, wherein the audio recording is directed.
Is not here.
Please.
If you want, pass. Yes, 60.
My lords, item number 60 to 62, my lords, I appear for the petitioner in this matter. My lords,
My
the
lords-
office note.
My lords, if I may interject, I'm so sorry, my lords. Apologies. My lords, from item number 60 to 62, my lords, as my learned friend mentioned, my lords, it's a batch matter, my lords. It is also connected matter, my lords. This connected matter is placed before Justice Magdum this Friday, my lords, 13th of February, my lords. Kindly tag this matter along, my lords. It is on the same ground, my lords.
What is this? Why should
Well,
this matter be tagged on to the other matters in principal bench?
My lords?
No, why should this be tagged on to the other matters? Is it arising from this bench? Connected matters?
My lords, it's the reason being, my lords, the matter is challenging on the same grounds, my lords. It's the tariff order being challenged, my lords.
That's what I'm asking. Whether those matters that are pending before Justice Magdum or of Dharwad bench.
No, my lords. These matters were not tagged along, my lords, on the previous
Why
occasion.
Bangalore bench matters will be heard there. Dharwad bench matters will be heard here. Why should it be tagged to that?
Your Lordship, if I may, I appear for the SLDC and KPTCL, Your Lordship. Matters of this, the Dharwad bench are also tagged in the Bangalore
Tagged
bench matters,
along
Your
with
Lordship.
that.
Yes, yes.
Please,
There are a
my
few
lord.
matters, not these matters, Your Lordship, but there are different matters of this bench as well, which are tagged along with the main, in the principal bench matters. Reason being, Your Lordship, a
My lords,
special
common
direction was
tariff
sought by
order.
the Chief Justice.
My lords, if my lords may permit, my lords, if my learned friend could be patient and I would have assisted your lordships. I was about to make the same submission, my lords. The office noting is that the first writ petition, which was before your lordships, has been transferred, my lords, to the principal bench. Reason being, my lords, the same tariff order has been challenged, my lords, in several other writ petitions before the principal bench as well. Now, this is a tariff order, my lords, of KARC, my lords, which is applicable to several sugar factories situated, my lord, across Karnataka. So, my lord, there is a batch of matters before the principal bench and other set of matters, my lords, before your lordships. So, what my learned friend was trying to assist your lordships was, one matter, my lords, that was before your lordships has been transferred. The same order that was passed, my lords, in the matter which has been transferred, my lords, is been followed in the item number 60 to 62. So, my lords, consequently, my lords, these three petitions also, my lords, would follow suit. And these petitions also, my lords, ought to be transferred before the principal bench.
It is submitted that the WP number 108787 of 2025 is sent to the principal bench to post along with WP number 21509 of 2025. Then council submits at 62 and 63 are also
No, 61 and 62, my lords, I beg your pardon. 61 and 62. In all three matters, items 60, 61 and 62.
Yes.
60 and 61 is already sent to the principal bench. This 62 is also connected with the same. This also
Please,
will be
Please.
sent to the principal bench where the matters are pending consideration and they are likely they are coming up on 15th February. The discharge judicial is directed to place these matters along with so and so to the principal bench along with so and so. Yes.
I'm so deeply obliged. And my lords, my sincere apologies for any confusion which we may have created.
Yes.
Sorry.
Much obliged, my
I'm
lords.
deeply
Apologies
obliged.
for the confusion.
63. Yeah,
Krishna Millards is a pediatrician.
Venkatesh Karvi.
They own a hospital, Millards. The wife is also a doctor. Lords, in fact, Lords, he has applied, Lords, for the renewal of his passport. But, Lords, the same has been, Lords, refused on the ground that, Lords, two criminal cases
Passing
are
the
pending
endorsement
against
dated
him.
issued by respondent number 2. Renewal of the passport has been refused.
Lords, because of the pendency of the two criminal cases.
Who appears?
Lords, on the last occasion, there was a notice, Lords, that was issued. And I've served the copies also, Lords. Venkatesh Karvi appears.
Please inform him. We will take it up in the afternoon.
Yes.
Password.
Password.
Yes, 64.
63 password. Admission matter, seal number 64.
Admit post for final hearing TCR. Yes, 65.
64 has to be remanded.
Huh?
It needs to be remanded back to the.
It is my lord, Supreme Court, from Supreme Court, in connected husband, this wife is before your lordships. Husband matter came to be dismissed. And my lords, he has filed a review petition that came to be dismissed. And he approached the Apex Court. Recently, Apex Court has set aside the order of the, my lords, this honorable court, and by upholding the compensation awarded by the tribunal, since he has not preferred any appeal before this honorable court, that 40,000, the Apex Court has come to the conclusion he is entitled.
You know the order? What is that order?
Yes, yes.
No,
I
that
already-
is that. But now the wife is before this court in respect of injuries. And the tribunal has dismissed that petition only on the ground that the accident has not been proved, because in the High Court that was the finding given by the court. So now the finding has to be given in respect of disability and other aspects. So it has to be remanded according to me.
Instead,
For what purpose to be remanded? What is to be proved by the court, before the court?
Because no finding has been given in respect of any other aspect, only in respect of evidence, the petition has been dismissed.
No, but in respect to the very same accident,
In respect, but at
accident
least
when it is upheld by the Supreme
Correct.
Court, why there should be an independent inquiry with regard
because
to the,
no finding has been given in respect of disability that has been caused to the petitioner there.
what are the facts of the case? How the accident had taken place?
wife is proceeding on a motor vehicle of
Motor
her
vehicle.
husband as a pillion rider. At that time, one Tata car has,
The husband is the rider of the vehicle.
yes, ma'am.
Hmm.
And now that attains finality in view of the Apex Court Act.
What is the order given in respect of the husband?
Same identity of the vehicle and involvement of the vehicle is in dispute. That Apex Court has clarified about that in para 3 of the Apex, para 4 of the Apex.
Negligence and all, when it
Yes.
is a pillion rider, where is the question of negligence to be decided?
Only my lords has to
No,
decide.
what
with-
has happened is there were two vehicles were involved in the accident. So in respect of the vehicle which has caused the accident, according to the petitioners, High Court has given a finding that that is not the
That is
vehicle.
satisfied by the apex.
That is satisfied by the Apex
As
Court.
far as the
No, as far as
accident
wife's
issue,
petition is concerned, no finding has been given in respect of the disability that is being caused to her. A finding is given only in respect of the negligence or the involvement of the vehicle is concerned. In respect of other aspect, nothing has been given.
admit post for final hearing, call for the TCR, case 66.
Like TCR before your lordships.
We'll see, post this matter after 3 weeks. Yes.
Number 65, and number 66. Ravindra Armane.
Yes.
Yes, my lord. My lord,
Ravindra
insurance
Armane.
company appeal only on quantum of compensation, my lord.
I am for R1, my lord.
Case of injury, I have served the copy, your lordship.
Yes, my lord.
Copy is
Yes,
served.
sir.
My lord, the tribunal has awarded compensation of 15,44,776 in respect of head injury, my lord. A psychiatrist has been examined who never treated the patient. And he has assessed mental disability to the extent of 45 to 50%, which has been challenged, my lord. Psychiatrist is not a person, my lord, who can issue the disability certificate, my humble submission. And therefore, the admitted amount of compensation, my lord, is 6,23,776. So stay may kindly be granted, my lord, subject to deposit of 50%, and let him withdraw the admitted amount, my lord.
Please, my lord. Award amount is 50,44,776. They are required to deposit 50% at least with proportionate interest, and the amount deposited may kindly be ordered to be released to the
Let's
petitioner.
also for the insurance company, whether the insurance company is on the ground of quantum, where the court, considering the evidence of a psychologist, has considered the disability. It is submitted that according to the insurance company, an amount of rupees 6,23,776, the petitioner is entitled. Land counsel for the claimant as on caveat is before this court and the papers are served on him. It is submitted that they are supposed to deposit 50% of the amount and they may be permitted to withdraw the same. Next para. Considering the submission of the land on either side, they shall stay of all further proceedings on the condition that the insurance company shall deposit 50% of the amount within 4 weeks from the date of within 4 weeks, and the respondent claimant is at liberty to withdraw an amount of rupees 6,23,776 as per the conditions laid down in the order in the above. Yes.
At least 2 weeks, madam, 4 weeks.
We will not, because you have filed caveat, we will not pass a different order. That is a usual order.
Yes, yes, ma'am. He has suffered a head injury, my lord.
4 weeks, sir.
That amount may kindly be released to him, sir.
That's what I said.
Please, please, ma'am.
Yes.
Preliminary B group matter, seal number 67. Prashant has first money.
Please, my lord.
Prashant has first money.
Password.
Password.
68.
Amaj.
Your Lordship, I appear for the petitioner in this matter, Your Lordship. I've received the mandate.
I'm filing memo for retirement, my lords. Petitioner, retirement, my lords. Petitioner advocate is now in the panel of KNL and respondent number 4 is the KNL. He is disabled. So this is informed to the client.
The petitioner as filed. Then where is the, where did you inform him?
I will inform the client, my lords.
The other counsel.
Other counsels, I am.
The other counsel, I think,
Your Lordship, I appear for petitioner, Your Lordship. We have received the mandate to appear on behalf of the petitioner.
So
I'll be
so
filing
submits
my
that.
wakalat,
We have
Your Lordship.
instructions to, who is going to file wakalat?
Ajay Nandalike from Pragati Law Chambers. Your Lordship.
What is the name?
Ajay J. Nandalike, Your Lordship.
So and so has instructions to file wakalat. Land counsel for the petitioner, Mr. Arvind D. Kulkarni had filed a memo of retirement. Is for, as he is appointed as a counsel for
KNL, my lord.
R4.
Please, my lords.
Counsel for R4 has already, another counsel has instructions to file wakalat.
He's in the panel of KNL, not a counsel for R4.
Oh.
Arvind D. Kulkarni,
So
but
he is
he's
the panel of counsels for R4. He is permitted to retire. Print the name of so and so. This is
Your
matter after 1 week, 2 weeks, A69.
2 weeks. Seal number 69. RM Kulkarni. Chetan Munwali. If you party.
Here for the petitioner, my lords. That's the challenging, my lords, 4D effect, my lords, division affected by the respondents. That's impugned orders, my lords, are in Kannada. If my lords permit, I will, my lords, make submissions.
Please, we'll hear it after lunch.
Pass.
Obliged.
Number 70. NP Vivek Mehta.
Do that. What is?
Yes, cross-examination of PW.
If you would be.
Where is that report? Pendency of the court of senior as per order dated 9/2/2026. Your cases of which year?
2021, madam.
2021.
21.
This is a suit?
It is a suit for permanent injunction.
Where is other side?
Yesterday.
Password.
Would be. Pass.
Yes.
71. 71 Arjan. Seal number 72. Santosh Bhimane.
Yes, remaining matters after lunch.
Sincere apologies, Your Lordship. I was held up in court number 8, Your Lordship. Serial number 55. Kindly, interim order may be extended, Your Lordship.
Yes, 55 interim order extra.
Obliged.
For respondent in this matter, my lord, date may be fixed, my lord.
Give some date in the month of March, April, March.
Yes. Serial number 55.
Sir, adjournment.
10th March, 55.
For adjournment ಕೊಡ್ತೀರಿ.
10th March.
कोर्ट ऑफिसर कर लिया ಹಲೋ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹಾ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಹಾ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 67.
63 ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ.
67 ಸರ್. 67 ಸರ್.
ಅದೇ 67 ಪಾಸ್ವರ್ಡ್ ಆಗಿದೆ, ಪಾಸ್ವರ್ಡ್.
ಅದೇ ಸರ್ ಕರಿತೀರಲ್ಲ ಸರ್?
ಹೌದು ಸರ್, ಕರಿತೀವಿ ಸರ್.
ಆಯ್ತು ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 76 ನಮ್ದು.
ಹಾ 76 ಸರಿ ಸರ್.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ನಾ ಬಸವನಗೌಡರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀನಿ.
ಹ್ಞೂ ಸರ್ ಇದೆ ಸರ್.
ಓಕೆ.
ಬಸವನಗೌಡ ಟಿ ಅವರಿಗೆ ಸರ್.
ನನ್ನ ಹೆಸರು SP ಕುಲಕರ್ಣಿ ಅಂತ ಹೇಳಿ.
ಹ್ಞೂ
ಸರ್ ನಾ ನಮಾಜಿ SR ನಮಾಜಿ ಅಂತ ರೆಸ್ಪಾಂಡೆಂಟ್ 67 ನಲ್ಲಿ ಸರ್.
ಹ್ಞೂ ಸರ್.
Court officer, ಮ್ಯೂಟ್ ಆಗಿದೆ ನೋಡಿ.
ಇಲ್ಲ.
72, seal
What's
number
the-
72.
The petitioner, my lords, has contested for election, council election, municipal council election from ward number 13, which is, my lords, reserved for, my lords, category 2A. At the same time, my lords, the respondent number 6, my lords, obtaining, my lords, a false certificate contrary to, my lords, his school records, claimed himself to be, my lords, belongs to the 2A category, has contested the election. The caste certificate has been questioned by, my lords, the petitioner before, my lords, the Tahsildar. The Tahsildar, despite, my lords, we providing, my lords, the school records of, my lords, respondent number 6, which says that, my lords, he belongs to, my lords, Hindu Lingayat community, which does not fall within, my lords, the category of, my lords, 2A, has, my lords, slightly brushed aside the fact that, my lords, he belongs to some other community and he has obtained, my lords, his.
What is this order dated 2/2/2023?
Please.
Where is that order?
Lords, it is at Annexure H, my lords. This is passed by, my lords, the Assistant Commissioner.
Page number?
Page number 39, my lords. It's in Kannada, my lords. I have produced, my lords, the English translation of the same.
Where is it?
Lords, it is produced along with, my lords, a memo. Lords, Annexure B and F.
The order passed by the Assistant Commissioner is confirmed by the Deputy Commissioner.
Please, my lords.
What is the order of the Assistant
This-
Commissioner?
The Assistant Commissioner says that, my lords, since, my lords, the sixth respondent has sworn to an affidavit saying that, my lords, in the event, my lords, the certificate produced by him found to be false, my lords, he is open for, my lords, the penal prosecution. And, my lords, they have recorded some statement of, my lords, some of the persons who say, who are, my lords, are residing, my lords, there in the vicinity of, my lords, the respondent number 6 residential house. And, my lords, a certificate issued by, my lords, the community, my lords, a particular community which falls, my lords, within 2A.
Let's read it, this copy.
Please. In the present case, the
The caste certificate of the sixth respondent.
please, my lords, because, my lords, both of them, they have contested
Let's
the.
go straight away, go to the Assistant Commissioner's order first.
Please. In the present case, the appellant, Mr. Raju Shankar Rao Ambore, resident of Sri Sai Kupa so and so, filed an appeal before this office on 25/10/2021, questioning the Hindu Gaudi category 1 caste verification certificate.
You don't have page numbers to this. Translated copy of Annexure 2.
Annexure H, my lords.
Annexure H.
Please.
Please read.
And the caste certificate bearing number so and so, dated 22/6/2021, obtained by Mr. Suresh Fakirappa Bedre, resident near Basappa Kanawalli, Dharwad, from the Taluk grade 2, Tahsildar grade 2, Dharwad, for the purpose of contesting Hubli Dharwad Municipal Corporation election. The appeal was filed under section 4B of the aforesaid act. As requested by the appellant, the case was treated as an appeal under the provisions of the said act. Notices were issued to both the parties on 28/10/2021, and the case was posted for hearing on so and so, so and so. The matter was heard in this office on so and so, so and so, and finally on 19/9/2022, after which the matter was reserved for orders.
The said proceedings, Mr. Raju Shankara Ambar, a resident of Sai Krupa so and so, was treated as an appellant, and one Mr. Suresh Pakirappa Bedre, 2 Tahsildar Grade 2 Dharwad, Revenue Inspector Dharwad, and Village Accountant Dharwad were treated as respondents. However, during the hearing on 30/11/2021, it came to light that Mrs. Chandrakala G, wife of Nagaraj V, resident near Tavargiri Nursing Home near KC Park, Post Office, Dharwad, had filed an appeal before the Honorable Deputy Commissioner Dharwad. As the Honorable Deputy Commissioner issued a stay order on the proceedings of this office, the hearing of the present case was stayed. Subsequently, by order number so and so, dated 21/5/2022, the Honorable Deputy Commissioner Dharwad, after considering the application of Mrs. Chandrakala, who is petitioner in the second petition, near Tavargiri Hospital and so and so, was taken up for hearing again, treating Mrs. Chandrakala G as respond number 2, and notice was issued to her on 25/5/2022, and the case was proceeded with. On behalf of the appellant Sri Srikant T. Patil, advocate, and Sri Rohit S. Patil, advocates, residents of Kalyan so and so, appeared after filing Wakalatnama. On behalf.
Come to this page 3 of the translated copy. Read paragraph number 3. What is this order? You have not given her the translated copy.
I have served.
That translated copy, translation of H,
Memo.
annexure H.
Good.
Paragraph 3. Page 3, paragraph 3.
On the other hand, the learned counsel appearing for respondent.
The fourth para,
Further.
respondent number 2, 3 and
Respondent number 2, 3 and 4, namely Tahsildar grade 2 Dharwad, the revenue inspector Dharwad, and the village accountant Dharwad filed a joint statement stating that with regard to the Hindu Gauli category A caste certificate obtained by Mr. Suresh Fakirappa Bedre, the village accountant Dharwad conducted a local inspection and verified the school records wherein the caste was recorded as Hindu Lingayat. Upon inquiry with the village punch witnesses, it was found that the entry Lingayat was made inadvertently.
What is that? It will happen like that.
Your Lordship,
What is the procedure?
in the
What is the procedure under that? Now, school record says that he is a Hindu Lingayat.
Lingayat.
Now, he has verified with the punch witnesses. They said that it is by inadvertence. Who are they to tell when something is recorded in the school records?
Their statements were recorded, Your Lordship, where they
And
have
what is the
stated.
procedure? That I want to know.
Till date, no attempt is made even to correct those entries.
Please show the procedure. What is the procedure contemplated?
Section 4, rule 4 is the power of issuing the certificates.
Rule 4.
That's
Caste
rule.
verification
Please.
committee.
Please,
Now, who has given the certificate caste
the
verification committee?
Tahsildar, my lords.
Tehsildar has
Tahsildar.
Oh.
Then, my lords, we have disputed that caste certificate. He refused to, my lords, and
Give the certificate.
my lords,
Who has to give? Who is the competent authority to
the
grant?
Tahsildar, my lords. Tahsildar.
Where do you get that under the act?
My lords, 4A, my lords.
4. There shall be a committee called the caste verification committee, caste certificate, person belong to scheduled caste, the deputy commissioner. Now, where from you get the tehsildar? The
Lords,
tehsildar of taluk. This is a committee.
Rules of 1990, my lords.
90.
90.
This is rule 92, I think I'm looking.
Please.
90.
1990.
90. Yes.
Which says, my lords, in the event of, my lords, any dispute, the dispute should be, my lords, referred to, my lords, the caste verification committee. There they have to, my lords, verify whether the validity of the caste certificate. And then, my lords, they can validate the caste certificate, or, my lords, they can cancel it. Instead, my lords, here, my lords, the Tahsildar did not, my lords.
You have to read 3A. 3A
Please.
deals about issuance of caste certificate
Please.
by the tehsildar. 4 deals with caste verification committee.
Please, please.
During the course of come to 3A, 2B. You got it? Rule 3A, 2B. 3B. It is under 1992 rules.
92. Because my lords, the entire proceedings have been taken place under my lords 1990 rules. Because there, my lords, the appeal is provided.
My lord, the appropriate act is, my lord, the Karnataka Scheduled Castes, Scheduled Tribes and other backward classes Reservation of Appointment, etc. Act 1990.
Why 1992 don't apply?
My lord, it is a rule, my lord. As per section 4A of the 1990 Act, my lord, Tahsildar has been given a power to issue the caste certificate, my lord. May I take your lordship to section 4A of the 1990 Act, my lord?
1990 Act is in Kannada.
The both are there.
Also English version. After Kannada version, there is English.
It is in Kannada completely. What are these 1992 rules?
My lord, it is also a rules, my lord, wherein, my lord, when there is a dispute, my lord, the assistant commissioner has to take inquire with the local officials, my lord. There also, the assistant commissioner has followed the procedure, my lord. The rule prescribes for beating of the drum in the local area, my lord.
Take the book from him. You also keep those, that book should be there, updated book.
Section 4A of the Act, my lord.
Hmm.
Issue of caste certificate and income and caste certificate.
The 1990 rules, it is 3A.
Please,
That's the only difference. No, it says
4A sub rule 3, my lord. The Tahsildar may, on receipt of an application under subsection 1 and 2, and after holding such inquiry as he deems fit and satisfying himself regarding the genuineness of the claim made by the applicant, pass an order issuing caste certificate or, as the case may be, an income certificate in such a form as may be prescribed, or rejecting the application. Further, the Tahsildar shall follow such procedure as may be prescribed before passing under subsection 3. So he has conducted the local inspection, my lord.
no, the school record says that you belong to a particular community. Or without any change in the school records, how is it open to say that?
My lord, what happened, my lord? The sixth respondent belongs to Gauli community, my lord, and his forefathers are conducting the dairy business, my lord. That's why, my lord, he has taken the caste certificate under section 4.
What was the age of the sixth respondent as on the date?
Please, my lord. $53, my lord.
No, 53 years, entire school record says that he belongs to Lingayat community. And suddenly a caste certificate is issued saying
No,
that
not only this, my lord. Entire family certificate is also belongs to Gauli only, my lord.
Where is that? Where do you get that?
Yes, my lord. The Tahsildar, before issuing the even, my lord, may I take your lordship to?
Is it not for you to clarify those records?
Yes, my lord, I have clarified, my lord.
Then you have got it. You have got it. You
I have
sought
filed
for any
objection also, my lord. I have
changes in
filed
the
objection. Sorry, my lord.
changes in the said record.
Your lordship may kindly see the annexure. R1, my lord. Sorry, my lord, it is in Kannada, my lord. Along with my statement of objection, my lord, it is page number 12, my lord. It is annexure R1, my lord. It is in Kannada, my lord. I will furnish, my lord, translated copy.
Where is order in the appeal?
My lord, it is at page number 44, my lord. It
That
is the
is
order
in,
of the deputy commissioner, my lord.
Let's
for that
Is
also you
in
filed a
English.
translated copy.
let's
That is
all
in
the
English, my
Kannada
lord.
documents let's have got
That is
filed
in
the
English.
translated copies.
The section page number 44 is the in English, my lord. It is order passed by the DC, my lord.
Where do you get that in the translated copy?
So next is J, page 44, minutes, the revision order minutes by the deputy commissioner.
So that is in English.
That is in English.
That is in English, my lord.
Page number 44 minutes.
44, my lord.
Para 9, 10, and 11, Your Lordship.
11.
12.
Para number 11, it was specifically stated that, my lord, even in school certificate of sisters and brother of respond number 1, namely Sumitra Bedre, Rohan Bedre, wherein it is stated that they belong to Hindu Koli community. Even government notification dated 27/6/1991 and another government notification 12/3/2000 have also been considered by the Executive Commissioner Dharwad. When there are different documents relating to respond number 1 Suresh Bedre, where it is stated belongs to Hindu Gaudi community. Under these such circumstances, only on the basis of school certificate cannot be concluded Suresh Bedre does not belong to Hindu Gaudi community, but he belongs to Hindu Lingayat community. Even it is not clear who admitted the Suresh Bedre in school and whether that person was actually knowing to which caste Suresh Bedre belongs to. When villager statement, Panchanama prepared by the village accountant in the presence of Panchana, certificate issued by the president of Hindu Gaudi Samaj and sworn to the affidavit of Suresh Bedre, in view of the such documents, they can be accepted that he belongs to Gaudi community. The school certificate of Bedre that he belongs to Hindu Lingayat community was that alone document does not disprove the other various documents referred to.
Yes.
So all those documents, my lords, either are came into existence, my lords, after 2021, my lords, or my lords, the school certificates of my lords, his relatives, the children's school certificate, etc., they came in existence, my lords, after 2021. My lords, he has not even made, my lords, an attempt. Even after, my lords, these many years, he has not even made an attempt, my lords, to get the records, school records corrected. Till date, my lords, they remain the same. And now, my lords, based on only, my lords, some of the statements made by, my lords, the local residents and, my lords, association of, my lords, particular community, saying that, my lords, he belongs to a particular community who can contest the election as 2A. My lords, brushing aside, my lords, the documents which are created at my lords, I am the opponent contestant.
He's a defeated candidate, my lord.
And in the second petition, my lords, the voter of, my lords, the constituency.
Yes. Please come, take the both the red petition. Give the other red petition also.
In that case, my lord, he has sought for quo warranto, my lord. His prayer is for issuance of quo warranto. Same ground urged by him.
102411 of 2023 and WP 1001112 of 2022. These two red petitions are filed questioning the caste certificates issued in favor of the unofficial respondent. In first petition, the petitioner is the one who has contested in the elections and who was defeated in the election. The second is the voter of the said constituency. As they are both are questioning the caste certificate of the respondent, both the writ petitions are disposed of by way of a common order. Next part. Writ petition, the prayer that is sought is so and so. And writ petition number so and so, the prayer sought is as below. It is a case of the petitioner that The ward number 13 in Dharwad city is reserved for the candidates belong to backward class A. The respondent number 6, though he belongs to Hindu Lingayat community, has contested the election by obtaining fake caste certificate from the office of the respondents for the purpose of contesting elections as if he belongs to backward class A. And the fact that the respondent number 6 belongs to Hindu Lingayat community is evident from his school's certificate. The Hindu Lingayat is not included in the list of category of backward A classes. The respondent, being the candidate of the BJP, has also been issued with the ticket for ward number 13, where the petitioner was contesting the election, furnishing false information about the caste and pretending himself to be a person belonging to Hindu community. He has filed an election petition questioning the election of the 6th respondent. The petitioner, after getting the school records of the respondent number 6, has approached the 3rd respondent, that is the assistant commissioner, seeking for the recalling or the cancellation of the caste certificate issued by the 6th respondent. It was not entertained by the 3rd respondent. 3rd respondent is a Tehsildar. Agreed thereby that he has approached the assistant commissioner complaining about the issuance of the false certificate to the 6th respondent. Then the 2nd respondent, by way of order dated 29/9/2022, has rejected the case of the petitioner. The petitioner has carried that order in appeal before the deputy commissioner. And by order impugned dated 2/2/2023, he has confirmed the order of the assistant commissioner. Agreed thereby, the petitioner is before this court. Even in the other petitions also, the similar facts are stated. It is a contention of both the two counsels are appearing.
Please, separate.
It is a contention of both the counsels appearing on behalf of the petitioners on that. When the school certificate shows that he belongs to Lingayat community, the court ought not to have the first and second respondents ought to have conducted a detailed inquiry and ought to have cancelled the certificate that is issued in favor of the 6th respondent. It is submitted that the orders are passed on the ground that the other family members belongs to, what is that? Gauli community. Gauli community. And according to the land council of the petition, all those certificates are pressed into service in the year 2021. And basing on such certificates and basing on such panchnama, the caste certificate ought not to have been granted. And on complaint by the petitioner, the authorities, that is 2nd and the 1st, assistant commissioner and the deputy commissioner ought to have considered and ought to have passed a reasoned order. Then SCZP and the land council appearing to the 6th respondents submits that while issuing the caste certificate, a detailed inquiry was conducted. The inquiry panchanama was conducted. After verifying in the locality that the entire family belongs to the Gauli community, the caste certificate is issued. It is submitted that the petitioner, who is unsuccessful in the election and who was defeated, has come up before this court. It is submitted that both the deputy commissioner, both the assistant commissioner as the deputy commissioner, has passed an elaborate order and no interference is called for. Next, having heard so and so, there is the material on record. This court has perused the order, having heard the counsel, perused the order passed by the Deputy Commissioner. In the order of the Deputy Commissioner,
That is Annexure J, my lords, in the main petition.
Page number 44. Your
44, madam.
in the order of the Assistant Commissioner, in the order of the
Deputy.
Assistant Commissioner,
Deputy Commissioner.
this is J is the deputy or?
Deputy,
J
my
is the
lords.
deputy.
Deputy
In the
Commissioner.
order of the
Deputy
Deputy Commissioner, in the order of the Deputy Commissioner, in detail, it has been discussed that how the caste certificate is given to the sixth respondent. And also the fact that in the school records, it is mentioned as Hindu Lingayat. It is observed, it is discussed in the order that even in the school certificate of sister and brother of
Sisters,
sixth respondent,
children of sister and brother.
Huh?
Children of sister and brothers.
Sister
in the
and
school
brother.
certificates of the children of sister and brothers of the sixth respondent, it is stated that they belong to Hindu Gauli community. It is observed that the Gazette notification dated 27/6/1991 and another Gazette notification dated 12/3/2021 have also been considered with Assistant Commissioner Dharwad. It is observed with the Deputy Commissioner that when there are different documents relating to the respondent number 6, wherein it is stated that he belongs to Hindu Gauli community. Under such circumstances, only on the basis of the school leaving certificate, it cannot be concluded that he belongs to the Lingayat community. Even it is not clear who admitted the sixth respondent in school and whether that person was actually knowing to which caste he belongs to. When the villager's statement, Panchnama, prepared by the village accountant in the presence of Panchats, certificate issued with the president of Hindu Gauli Samaj and sworn affidavit of the sixth respondent. In the light of these documents, it can be accepted that he belongs to the Hindu Gauli community. Except the school certificate, all other documents evidence is in support of the case of the sixth respondent. The court, the Deputy Commissioner, on the basis of this, has come to the conclusion that the caste certificate of the sixth respondent, Panchnama prepared by the Grade 2 Tehsildar, Dharwad, and certificate issued by the Hindu Gauli Samaj, Dharwad, has come, on basing on that, the Assistant Commissioner has rightly come to the conclusion and dismissed the appeal. Accordingly, the Deputy Commissioner felt that there are no grounds to interfere. This court, having perused the said order, and in the light of the submissions made by the learned counsel for the petitioner, now this order needs to be appreciated by this court. No doubt, in the school records, it is mentioned as Hindu Lingayat. And when a detailed inquiry was conducted in the locality, all the relatives and all the relatives, as per the information and as per the Panchnama, they all belong to the Hindu Gauli community. Even the school records of the children also shows that they belong to the said community. In those circumstances, just because there is an entry in the school record with regard, the petitioner, the sixth respondent, no doubt would have taken appropriate steps to get those documents, to seek. You should have taken appropriate steps. Well, in the light of the entries in the school records are not, they're all the wrong entries, and he doesn't belong to the same. However, the fact remains is he has not taken such steps. in spite of the said fact that he has not taken steps. The material that is placed before the Assistant Commissioner and the Deputy Commissioner are relevant, and basing on that, both of them have rightly passed an order, and this court finds no reasons to interfere. Accordingly, dismissed.
Please.
Please.
Seal number 73, Deepak Nag. Mahantesh Hiremat.
Yes.
Please, my lord. The wife has filed this petition, my lord, against the rejection of
Yes.
against the rejection of her application under Family Courts Act for interim maintenance and right of residence, my lord.
Notice his order. Where is he? Mahantesh Hiremat.
Mahantesh Hiremat.
Was directed to take notice in connected matter, my lord.
What is the connected matter?
It was attachment for removal of the attachment of the property under surfacing.
Number.
It is disposed, my lord. May I file the file?
It's already disposed.
Yes, my lord. Demolition of the property, residential premises. Now, what remains is only the flat which he has to give. Now, already the bank has recovered its loan.
Got hand summons on the counsel for the respondent.
No, already served, my lord. This Mahantesh Hiremat, I already served, my lord.
No. Mahantesh Hiremat, we are asked. He is appearing here.
He was directed in that matter to appear. Both the writ were connected earlier, my lord.
Then what to do? Now he has not filed the wakalat so far. You take out hand summons on the counsel for the respondent before the trial court will decide it.
A shortest possible date may be given, my lord.
The petition is permitted to take
Because-
hand summons on the counsel appearing for the respondent and shall file a memo to that effect by 24th. If it is filed, this the matter on 25th.
Next week, the date may be fixed, my lord. Date may be fixed for me.
25th. If you
Please, my
file
lord.
on 24th,
Please,
it
my
will
lord.
come on 25th. Yes. Yes, next.
74. PR Patil.
My lord, in this case, the interim maintenance as a trial court has rejected. The ground that 2 decades they are
What are these two petitions?
My lord,
What are these two petitions?
one more petition is filed.
Challenged by the respondent before trial court, my lord, that 10,000 is awarded to son. That is we have questioned.
No, 74 is filed by the wife.
Yes, ma'am.
Questioning?
My lord,
Rejecting the claim of
Petitioner
petitioner
number 1.
for maintenance.
That is wife's case is rejected.
Yes, yes.
Wife's-
For the children it is granted.
Yes, ma'am.
How much is granted?
10,000 is.
only the
For
handicap.
enactment of that, you have come before the court.
No, my lord,
For questioning that order.
Yes.
So what is your income?
Lord, I am 68-year-old. I have no income, my lord. That I am getting some minor income from rent, my lord. That I have a sister and brothers, my lord, who are unsound mind. That is also observed by the
How
family.
much you are getting?
Plus, at the most, I am getting 14 to 15,000, man.
How much is granted by the court?
10,000, man.
How many are the children?
Pardon.
How many, number 2 or 3?
In respect of 3, my lords. Respond number 3.
Is aged about?
24 years, my lords, but he is also unsound mind. And one daughter is major. She is working in MNC and getting income of 80,000. And she also claimed that she is also having no source.
From how long they are living separately?
Around 25 years, ma'am.
So you have 2 children, out of that one is
Yes.
differently abled.
Yes. For that, family court granted maintenance, my lord.
Then from last 25 years, you have never sought for maintenance from husband?
My lord, due to the handicapped son, the respondent is not take back due to the handicapped son.
Last 25 years.
25 years due to her brothers are looking after her maintenance. After their brothers are no more, and she is unable to maintain herself.
You don't have properties?
I will produced the list of documents, the properties,
Take that.
more than 300 crores. I filed the petition.
Then?
More than 3 crores. Their property, 25 guntas in NA land, and one of the building is constructed. And after the filing this case, the respondent transferred all the properties in her sister's name, his sister's name.
These
I will find the
properties
list
are
of
not
documents.
belongs to petitioner ma, originally. It belongs to one of the deceased sister ma. They are unsound. Because of them, the properties are standing in the name of.
Have you filed the documents before the court?
I filed,
Where are they?
I filed the list.
You that?
Copy is not served on me, man. Copy is not.
Yes. Date to 18/8/2025. 18/8/2025, I filed the list of documents.
18/8, yes, it is here.
Yes,
Give him a set of papers.
yes,
Give him
subsequently.
the set of documents. Land counsel for the petition says the copy of the documents. On the land counsel for the respondent.
Kumar.
Land counsel for the respondent shall file an affidavit before this court,
Please.
referring to those transactions.
Even my lord, sir.
You file it, we will see.
Please.
This is matter on
2 years after my lords,
26,
now it is the.
My lord, the other side has stating that the 80,000, the daughter is the only 25,000 she is drawing the salary. I produced the salary certificate.
Let him now, if why all these facts were not stated before the court in your statement of assets and liabilities, that also will examine. Yes. 75.
Seal number 75.
N is under challenge, which is my license has been cancelled and it has been transferred to some other person without hearing me, without giving an opportunity. Last time it was
This order.
Annexure N, Tahsildar, my lords.
Again, you said there is no appeal.
No, my lords. And no. And last time lordships directed them.
Temporary arrangement has been made, your lordship. Because as he was expired, your lordship, temporary arrangement is made.
What is the order?
Your lordship, in view of the public interest, your lordship, temporary arrangement has been made.
What happened in this case?
He, your lordship,
Respond.
The order says, please read.
Temporarily, the fair price distribution has been transferred to respond number 6. That is what it says, my lords. Respond number 6 has been given the permission to allot, my lords. Since 2000, respond number 6 has been given to permission to distribute the food grains. Without there being any allegation against me, without hearing me, the fair price.
Impugned order says, that is what I am asking both of you.
Respond number 6, it has been transferred to respond number 6.
It is not transferred.
Temporary arrangement has
temporary
been made.
Temporary arrangement is not a transfer.
Temporarily, he has been given permission to distribute the fair price.
What about your case? What did he say in that order?
Nothing, my lords. Nothing, no allegation, nothing, my lords.
Then what order is passed? That is what I am asking.
Temporarily.
Apart from saying that temporary arrangement is made, before that you would have said something. Where is the order?
Annexure N, my lords.
Page number?
Page 41. 41, my lords.
No. Please read this order. Please read and translate.
Second paragraph, my lords. ಕಾರ್ಡುದಾರರಿಗೆ ಬೆಲೆ
In 21, there is only one para.
Before that order, my lords. Order portion, operative portion is at the last, my lords. Operative portion
You're
is
referring
the last.
to annexure?
Annexure N.
Yes. Yes.
Second paragraph from top, my lords. ಕಾರ್ಡುದಾರರಿಗೆ ಬೇರೆ ನ್ಯಾಯಬೆಲೆ ಅಂಗಡಿಯ ಜೋಡಣೆ ಮಾಡಿದ್ದಲ್ಲಿ 2 ದಿವಸ ವಿತರಣೆ ಮಾಡಿ ಹೋಗುವುದರಿಂದ ಪಡಿತರ ಚೀಟಿದಾರರಿಗೆ ತೊಂದರೆಯಾಗಿರುವುದರಿಂದ ಸರಿಯಾದ ಸಮಯಕ್ಕೆ ಪಡಿತರ ಚೀಟಿದಾರರಿಗೆ ಪಡಿತರ ವಿತರಣೆ ಮಾಡಲು ಸದರಿ ಗ್ರಾಮ ಸೀಮೆಯನ್ನೇ ಪ್ರಾಧಿಕಾರ ಹೊಂದಿರುವ ಮಂಜುನಾಥ್ ವೀರಪ್ಪನವರ ಸಾಕಿನ so and so, that is petitioner. ಇವರನ್ನು ನಿಯೋಜನೆ ಮಾಡಲಾಗಿತ್ತು. ಸದರಿಯವರ ಮೂಲ ದಾಖಲೆಗಳನ್ನು ಹಾಜರುಪಡಿಸದೇ ಇರುವುದರಿಂದ ಸದರಿಯವರ ಬದಲು ಜನತಾ ಬಜಾರ್ ನವಲ್ಗೊಂದ್ ಇವರಿಗೆ so and so. It is said that I have not produced the documents, required documents. That is the reason they have transferred to the respond number 6.
I think it's difficult for
Annexure
me to understand.
H also.
No.
Petitioner shall file the translated copy of the impugned order.
Please, my lords.
List is matter. The list is matter in the month of March.
Date 76.
Huh?
Date में cancel हो गई।
List is matter in the month of March, March 7th.
11.
No translated copy.
11.
Yes. Serial number 76, my lord. I am permitted to appear, my lord, for petitioner's counsel. Lord, petitioner, yesterday, my lord, I was very much present before the court. The petitioner before Lordship, my lord, is a Muslim by community. He is 77 years old, my lord. He wants to visit, my lord, Hajj and Umrah, my lord, for making his prayers and all that. Lord, there is a criminal case pending, my lord, before the JMFC court, my lord, at Raipur, that is Chhattisgarh, my lord, state. There, my lord, my party had made an application. My lord, page 34, could your lordship states. Page 34 is the order. Annexure H, my lord. Lordship gets that order, my lord.
What do you say?
My lord, so subsequently 2 times he was that extension is period is extended. On 2 times his period was extended, my lords. On last date, my lords, that is on my lords annexure, my lords, H, my lords, last page number, my lords. And
Passport is generally renewed for how many years?
only 1 year or 3 years, my lord. They are claiming for 10 years, my lords. So as per the my lords, page number 35, kindly see.
The passport, renew the passport.
Please.
Generally for how many years you renew
My,
for every
my
month?
lords, that is renewal for 10 years, my lord. Generally, it is 10 years. There is no criminal case is pending against him. So far as this petition is concerned, my lord, as per the rule 12 of the passport rules, my lords, rule 12. So partner can issue up to 10 years, my lords. But so far as regarding the circumstances, the case of the my lords, this honorable court and affects court has give only 1 year by filing a affidavit of the parties.
Relying on
So
certain
my lords,
judgments. Let us see.
my lord, page number 35.
Please come to the judgments which you are relying on. Judgments. Counsel for the petitioner.
Yes. Lord, page 16, my lord, our own High Court has granted
Page
10 years,
16.
my lord.
Page 60, my
Separate
lord.
judgments.
Shashi Kumar Pelli.
Yes.
Separate judgments. Separate judgments for it. Please.
Yes.
There are several judgments, a number of judgments. My lord, page 24, my lord, second judgment. After consideration of, my lord, all the aspects of the matter. My lord, my fundamental submission is, earlier, my lord, may I make one request, my lord? Earlier, my lord, 1996, my lord, 93, where the, my lord, they held the field, my lord. 25/8/1993 was the circular. It was replaced, my lord, by, my lord, a new official memorandum dated 10th of October 2019, which I submitted to Lordships on the last occasion, my lords. Dear my lords, on the second page, it is clarified, my lord, that Rule 12 extends even up to, my lord, 10
Which
years.
page, my lord?
Not
Page
beyond
could
10 years.
not get.
Second page. Second
It's
page
passed
of
on the
that.
official web front.
Yes.
Second page of that, my lord, official memorandum I have submitted yesterday.
Office memorandum, please.
Official memorandum dated, my lord, 10th of October 2019. It
Please.
replaces, my lord, the 1993 my lord, circular, which says, my lord, on the second page, my lord, earlier notification has been referred to. Last 3 lines in item 1, my lords. Rule 12 of the passport, so and so rules, only states that an ordinary passport shall be enforced for a period of 10 years, which implies that an ordinary passport cannot be issued beyond a period of 10 years. My submission is this, my lord. Fundamentally, problem is each time they give, my lord, 1 year, 2 years, there is a queue of lakhs people, my lord. Before I could get, my lord, visa, that expires again. I have to be that. That's what I wanted.
First of all, let's have the facts clear. There are criminal cases registered against you.
Yes.
This 10 years which you are referring to is on the normal for any other normal person. In case the cases are registered against them, what is the procedure? What is the rule?
All the judgments refer to the cases wherein cases are pending. All these
What they
cases,
say?
otherwise there is no occasion to come.
See, you are saying judgments, but you are not taking the court to the
No,
judgment.
I'll go through. One
Yes,
request
please
may I
take
make.
that.
One request may I make. On 19th, Lord, I am before Lordship Lord in another matter. I'll come personally because there are 2 other notifications again. On 19th,
Please.
on 19th, can I make a request? I'll come and argue the matter.
Yes.
Thank you. Number
19th, may I
77. Mallikarjun Swamy Hiremat. PGA?
Because in 77, I appeared on behalf of the advocate in 77.1, 2, and 3 village.
Yes.
But the matters all relate to the same temple. There are minor differences in the four matters before your ladyship today. The matters relate to the same temple and revolve around the interpretation of 2 or 3 provisions of the Karnataka Hindu Religious Institutions and Charitable Endowments Act
Yes.
and the powers of the hereditary trustee. If your ladyship kindly takes this statute.
No, first of all, which writ petition I have to take? WP?
If your ladyship takes 77.4 first, 77.3.
Give that file, 77.3.
Melody, may I make a submission? In 77, last time, after hearing some time, your lordship directed the government advocate to secure the records. That is the order passed by your.
The original records were ordered to be secured in the first matter because I had made a submission that the signature that is found in the impugned order, which is produced in the writ petition, and the one which is furnished under the Right to Information Act, bears altogether different dates. That is why in only first matter, your lordships are directed to secure the originals.
But even 77.1, my lord, the order of the deputy commissioner, order of the commissioner, appellate authority are necessary for a disposal of this one. I also made a submission, my lord.
There was some
No, but I
communication
have
gap.
produced certified copies,
I
sir.
apologize. My lord,
No,
I
records,
could not
entire
get the
records are
record
necessary.
because
Not the certified. I'm
matter
not
was
disputing the correctness of
communicated
the.
immediately.
Why it is not communicated?
Illa, because I had dictated it on 2/2/26 itself, but it was mailed on 6/2. So he has brought only records pertaining to one case, that too not full records. Sir. He is there in the office.
No, if it is in the first case, we will see. If he has brought it, we will see. Ask him to get it.
So 77.1, my lord, may be taken after receipt of the records. I have no objection.
In the first case, what is your contention?
So the order impugned is wherein there is a restriction that is put on the family members of the hereditary trustee not to enter the temple.
Give the first.
In fact, it's in Kannada. The impugned order is in Kannada.
This is the first one. Where is the impugned order?
Let's page 69 and extra G minute.
Page?
69 and extra G minutes. It is also a challenge in the connected matter.
69 is the impugned order.
Yes.
Who passed this?
So this order comes to be passed by the Deputy Commissioner, Vijayanagar District.
Deputy, what
Yes.
he says?
But this says, except the Dharmakarta of the temple, the other family members are not allowed to go inside the temple and to do it's a hereditary trust. But the family members used to assist the Dharmakarta, the head priest, in doing all rituals. Now, at the instance of some third persons, there is a direction issued saying that except the head priest, no other should enter the inside the temple. This is one without authority of law. First instance, there is no such order passed according to me. The reason why I am submitting this is, let's kindly see the signature that is found in Annexure G, which was furnished to us. Now, thereafter, I make an application under the Right to Information Act. Now, the order which is said to have been passed, signed by the Deputy Commissioner, bears altogether a different signature, which is furnished under the Right to Information Act. The one which was furnished herein bears altogether a different signature. Now, this was a mischief that was done by the executive officer who had communicated this to us at that point of time.
Sum and substance of it is one and the same.
The contents are same.
So let us not go into this. Let us go into, let us say how it is, this order is bad.
Yes. Now, right from day one, when my father was appointed as a head priest, we have been assisting him. It's like, if you also see section 2E, where a custom or usage is being followed in a temple. It includes hereditary trustees are concerned. The rights flows successively. Now, when my father is performing, if I am assisting him, the Deputy Commissioner under the Act has no power to restrict me so far as rituals are concerned. His rights or the powers that.
One person is the hereditary Akshaka of the temple.
Yes.
So according to you, all the family running.
No, no, no,
memo-
it's-
No, no,
yes.
maybe it is 10, 15, 20, whatever it is.
Yes.
Because it's a usage.
Yes.
All of them shall be assisting the main.
So far as religious activities are concerned, we are not interfering the administration. Lord, what the act mandates, the power of the deputy commissioner or the executive officer is restricted to what is provided under Rule 33B and its other provisions. That is so far as financial aspects are concerned and administration is concerned, but they have every right. Merely because it is notified.
No, even on the religious aspect
Yes.
are also concerned.
Yes.
They will do it. It is not that like 20 people will come and assist the main priest.
No,
So
if-
they shouldn't interfere.
No,
That is not the usage.
No, the scheme of the act is only to provide administration of, so far as administrative sites are concerned, Lord, if I can take your lordship.
So you can tell me, you can straight away answer to this.
Yes.
Now, a temple, you are the hereditary archaka.
Yes.
Now you want 20 people of your family to assist you. And you say that it is usage.
Yes.
And according to you, the deputy commissioner has no power to interfere.
Act
That is
doesn't-
not the law at all.
The act doesn't empower. Lord.
That's not the law.
No, let him show the source of power.
They have the administrative control over the affairs. You are not at liberty. Now the whole purport of continuing the hereditary archakas
Yes.
is continuing whatever the religious. That doesn't mean that you say that, not alone me, the entire world will come and assist. That is the
I'm not,
usage.
that is not my case at all. Lord.
Then-
I'm not saying, we are not outside. I can understand if a stranger comes and does this. But this is being done, let's,
Who are coming? Who are coming?
my son, my son and other family members are doing it. It's not,
Is that other family members? There should be some.
my brother's son and other persons. It is not, if my son or my brother's son come and assist me.
Once when you were doing all this before the act.
Yes.
That is how that is the whole purpose why this act has come into force.
Now, if you also see their argument in that, the challenge to the validity, if you also see the stand of the government in that, which is the subject matter before the Supreme Court now, they say, except for the purpose of administration, the act is framed and we are not doing anything beyond the administrative side. This is the stand taken.
As far as the age of retirement and other things of archakas are concerned,
Yes.
that is only stated by the.
That is if it is appointed under the act. Insofar as hereditary trust is concerned, right, they have no, any responsibility, power that is vested. That is their specific stand and that is contention that is even taken before this honorable court. Till the Supreme Court, their stand is clear. That it is only on administrative side and so far as financial aspects are concerned, they have the role.
Do you mean to say that the archaka is not under the religious, he is not under the control of the administration at all?
No, administration, he has been not given any power.
No. My question is not that.
Yes.
According to you, the archaka, the people who are discharging the administrative duties,
Yes.
the archaka is not under their control.
No,
He
if
will be
it-
doing his work independently. Is it your submission?
No, if only exception is hereditary trustee.
Whoever it is, let it be anybody.
No, so far as hereditary trustee is concerned, they have no power because the act is clear.
I think there are difference between a person who is working as an archaka.
Yes.
Hereditary
Yes, yes, ma'am.
trustee.
Yes.
Those are all different.
Yes, yes, ma'am.
You are an hereditary archaka.
No, I'm a hereditary trustee. Dharmakarta.
He is
Lady, I am representing the hereditary trustee.
That's all, my lord.
How is he concerned with the religious activities?
No, we have been performing. It is Dharmakarta who has been performing all these activities ever since from my father.
Dharmakarta come archaka.
No, that is the
No, he is
finding
not
given in
Archaka.
the Lord in the connected matter.
Sorry.
No, Archaka is something else, different.
No, you are
I'm
saying
not-
that you are performing the
Puja
duties
activities.
of a pujari.
Yes, yes.
That is means
Little
you
illate
are doing, you are a priest, you are a trustee.
That is being done from day one because all the religious activities are done by me.
I am accepting whatever you are saying.
Yes.
I am
No,
only
no.
asking.
I mean, not me, the other person who is a
Lady,
Dharmakarta.
I am representing the
I'm not-
hereditary trustee.
He is
No.
and who is he?
I am the family member who is assisting him in performing all these activities.
You have come to the court.
Yes, madam, because I have been restrained by virtue of this impugned order.
Supreme Court said Dharmakarta should be assisted by the family.
No, Supreme Court did not say so. That is the custom that we have been following.
It's not the way we interpret the section. Yes. What is the reason behind this?
My lord,
Why the order is passed?
The very order is passed.
My lady, if I may be heard first.
I'm led by my lord's, the senior counsel.
I will hear him. I'll hear him. Yes.
My lord,
What is the reason
your lordship
behind
may
this
look
order?
to the impugned order, my lord, what is the annexure G at 69. What he says, my lord, It is in Kannada. I will read and translate in English. ವಿಜಯನಗರ ಜಿಲ್ಲೆ ಶ್ರೀ ಮೈಲಾರಲಿಂಗೇಶ್ವರ ಸ್ವಾಮಿ ದೇವಾಲಯದ ಹಿತಾಸಕ್ತಿ ವಿರುದ್ಧ ಮತ್ತು ರೂಢಿ ಸಂಪ್ರದಾಯದ ಆಚರಣೆಗಳಲ್ಲಿ ತಾವುಗಳು ವಂಶ ಪಾರಂಪರ್ಯ ಧರ್ಮಕರ್ತರು ಭಾಗವಹಿಸದೆ ನಿಮ್ಮ ವಂಶಸ್ಥರು ಹಾಗೂ ನಿಮ್ಮ ಮಕ್ಕಳು ಭಾಗವಹಿಸುತ್ತಿರುವುದಾಗಿ ಹಾಗೂ ನೇರವಾಗಿ ಭಕ್ತಾದಿಗಳನ್ನು ನೇರವಾಗಿ ಗರ್ಭಗುಡಿಗೆ ಕರೆದುಕೊಂಡು ಪದೇ ಪದೇ ಗರ್ಭಗುಡಿ ಪ್ರವೇಶ ಮಾಡುತ್ತಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿದ್ದು, ಇದರಿಂದಾಗಿ ಧಾರ್ಮಿಕ ಪರಂಪರೆಗೆ ಹಾಗೂ ಆಡಳಿತಾತ್ಮಕ ದೃಷ್ಟಿಯಿಂದ ಭಕ್ತಾದಿಗಳಿಗೆ ತೊಂದರೆಯಾಗುತ್ತಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಪ್ರಯುಕ್ತ ತಾವುಗಳು ವಂಶಪಾರ್ಯ ಧರ್ಮಕರ್ತರು ತಮ್ಮ ಪೂಜಾ ಕೈಕಾರ್ಯಗಳನ್ನು ಮಾತ್ರ ಗರ್ಭಗುಡಿ ಪ್ರವೇಶ ಮಾಡತಕ್ಕದ್ದು. ಹಾಗೂ ಗರ್ಭಗುಡಿಯಲ್ಲಿ ನಿಯೋಜಿಸಿದ ಅರ್ಚಕರು ಹೊರತುಪಡಿಸಿ ಬೇರೆಯವರಿಗೆ ಪ್ರವೇಶ ಇರುವುದಿಲ್ಲ ಎಂದು ಆದೇಶಿಸಲಾಗಿದೆ. My lord, what he says, my lord, your family members, your sons, and all those persons cannot go into the sanctorium because only you, that too, wherever there is a, my lord, the religious functions are there connected to the Dharmakarta, then only he can enter into the Garbhagudi, not otherwise. So they have restricted, my lord, that's all. You cannot, and that too, you cannot bring somebody outside, your friends or your relatives, directly into the Garbhagudi. That's what you are disturbing it, Archaka.
Now, this person, the Dharmakarta,
Yes.
is also a priest.
Yes.
No, he's not a priest.
No,
That
not
is
at
the
all.
subject
I
matter.
am is my assertion. I am is my assertion, my lady.
That is the
The
subject
Pradhana
matter.
Archaka is appointed. Here is Archakas.
Archaka is appointed as a secular staff.
Hereditary Archaka.
They are hereditary archakas.
There is a
Hereditary is
Pradhana
there.
Archaka of the temple.
Yes, my lord.
No, there is a
He is
dispute on
doing
that
his
also, my lady. I'll explain.
We can't interfere into that.
This order permit the Dharmakarta. In this order, permit the Dharmakarta to enter the Garbhagudi.
They for religious purpose.
Not family members.
Yes. We'll hear
That's all the
senior-
order, my lord.
Yes, Mr. Senior Counsel.
Really, if first, if I request your ladyship to take the two provisions, and that will clarify some of the questions your ladyship just asked.
Yes. Yes.
First, your ladyship comes to 25A of the Act, 25 capital A.
Yes. Yes.
So subsection 1, it says no committee of management shall be constituted in respect of the notified institutions managed exclusively by hereditary trustees. The power of management shall vest in such hereditary trustee. Now, I am the hereditary trustee of this temple, Sri Mailaralingeshwara temple, and as per the provisions of section 25A, the power of management vests in me. The second section I would request your ladyship to come to is section 58.
Yes.
The commissioner, deputy commissioner, now this impugned order is passed by the deputy commissioner. I've impugned that order in my writ as well. And assistant commissioner and every other person exercising powers of performing functions under the act shall not interfere with and shall observe the customs, usages, ceremonies, and practices appropriate to the notified institution or declared institution in respect of which such powers are exercised. Now, two principles are very clear, your ladyship, from 25A and 58, that as far as notified institutions are concerned, the power of management vests exclusively in the hereditary trustee. That's the first principle. That's very clear from the language of the act itself. The second point is that as far as religious practices go, the deputy commissioner or any other officer does not have the right to interfere with the religious practices.
Then
Now,
there would be a, no, before you proceed
Yes,
further.
yes, ma'am,
No,
yes.
there would be a register for every institution.
Yes.
Register for a property register where it includes the usages and the customs of the temple. That is
Yes.
defined under which section? A
Now, the
register is
legal-
maintained in
Yes.
respect of every institution.
Yes,
So,
now-
what are the usages of the temple? What are the customs of the temple? They are all
Yes.
codified under the said register.
Yes, not
Now-
in this.
Now,
Yes.
a temple where there is a hereditary, like which the one you read, section 25A.
Yes.
The department will not appoint the board of trustees.
Yes.
The hereditary trustee will be taking care of the
Yes.
affairs.
Yes.
But still, the hereditary trustee is under the management or under the administration because it's a notified temple, whether it's the assistant commissioner or the deputy commissioner. The orders that are given from time to time, he is under him.
Yes.
Is there any dispute on that?
No, I am not under any officer. As there is an executive officer who is appointed by the government to help in the administration so far as non-religious activities are concerned in terms of money and other things. There is an executive officer appointed, and that is pursuant to the order when I was appointed as a hereditary trustee, and I'll point out that order. It requires me also to follow the provisions of this act. But I'll point that out, Your Ladyship, in just a minute. But to your question, Your Ladyship, on the practices of each temple. Now, there are in our state, Your Ladyship, there are temples belonging to different denominations and different kinds of temples. In certain temples, which are more attuned to the religious practices of certain kinds of castes and categories, there are some codified practices. In our temple, the origin of the temple is such that the writing of any rule book regarding practices is not there. And this is shown in the scheme in the earlier act, wherein the scheme was set out. This is under the pre-independence when the scheme was set out, and I produced that also. When the scheme was set out, the practices have been notified. And my powers in respect of those under that scheme is what has been followed since then. That is, since 1920 onwards, that scheme has been followed. That continues. So there is no book which says, for example, which is what your ladyship is asking, there is no book which says this is a practice A which Y has to do, this is a practice B which C has to do. So the customs that has been followed over the last 70 years is that the hereditary trustee has been determined of these practices. Now,
there is no evidence.
No, 1 second, sir. Why should you interrupt? You make your submissions after I finish. I'm sure the ladyship will hear you patiently also. Let me finish, sir. Now, and what this is there in the scheme that has been approved, and I have produced that scheme. I'll come to that in a minute, your ladyship. So the response to your question, your ladyship, in a simple answer is there is no register which says, as your ladyship asked, no register or codified book which says what the practices and customs are. Because some of these temples have come purely by customary practices over the years. It's not in a book as such, not in a book form as such.
Because once a temple is notified,
yes,
book has to be maintained. A register will be maintained. That is as per the framework under the Act, which says who are the religious staff, who are otherwise secular staff, what is the properties that are belonging to the temple. Everything, there would be a book.
Yes, in respect of the assets of the temple, all of that, there are records, and I will take instructions on what that book is, and I can produce that.
What I'm not able to understand is,
yes,
under the guise of the custom,
yes,
now the whole purpose is to bring all these temples under an administration where it will be going in a very transparent manner. Now, under the guise of this religious practice, you say that without any number, without who is that, who is entering into the temple, nothing, some random persons are coming into the temple, and you say that nobody has any control, and because we are the hereditary trustees, we will be doing it. How it is justified?
Not at all, Your Lordship. That is not my case at all. In fact, the order which was read out in the other petition also, there is no basis for that order is the contention. I'll come back to that. But the answer to your ladyship's question is, our case is not that I will bring whoever I want. That is not the case. In fact, we are hereditary trustees for almost six or seven generations. We are not, and this is not, it is the first time that such an order is being passed in respect of our family. So it is not that we are creating a commotion by bringing in all sorts of people. We are committed to this temple, your ladyship, as much as anybody else. In fact, the myth of this temple, your ladyship, is that when the Malaralinga, it arose from the ground, and the hereditary trustee always follows. Hereditary trustee always is standing ahead and goes along with the temple's icon whenever it goes on tour and all that. So I will show that also. That is also recorded. So there is no allegation that there is any commotion. There is no a letter written by anyone to anyone about such commotion being happening. And this order has been passed without giving an excuse to be heard by anyone. Let's suppose there are two questions I'm raising, Your Ladyship, in my two petitions. One, under what power the DC is exercising this, has passed this order? That's the first question, because they've not specified in the letter or the notification under which section it's there. No, it's silent. It's just a letter. That's the first point. Second, there was and I'll take Your Ladyship through the sequence. In some other case, under section 25B, there was a question to be determined whether that position was hereditary or not. It was a position of, I'll come to that, but that is a proper exercise of power. In that case, and that is 77.1, without, in an unrelated matter, they casually passed an order saying, I am hearing there are other things happening, can you make an inquiry? Without being heard at all. And I'll point that out. So the grounds that we are challenging is twofold. One, there is no provision that is referred to in the order. It is without, and there's no reference to 25A. Then in some other proceeding where the power, and that power vests with the assistant commissioner, to if there is a fight, Your Ladyship, between two people about who is the proper, the legal heir, ancestral heir to occupy some ancestral office, or if there is a question as to whether some office is occupied by an ancestral right or otherwise. Those kind of questions is determined by the deputy commissioner under 25B. When in such a proceeding, he passes an order directing an inquiry against the hereditary trustee on the ground that there may be some misuse, pure speculation, and without any letter, without any notice. And then there's there's a subsequent letter where they write to the hereditary trustee asking, can you give an explanation? And before the explanation is given, an order is passed of the nature that my learned friend read in the other matter. So we are challenging on 2 or 3 grounds. One, it's a clear violation of 25A and 58, because in 58, Your Ladyship, the religious practices which have been followed from so many years cannot be interfered with. Now, the explanation in this notice which my learned friend read out, it says that I am interfering with the religious practices. There is no mention of what religious practices is, and the law is exactly the opposite, that the district commissioner cannot intervene in the religious practices. Now,
the whole difficulty here is what
Yes.
is a religious practice?
Yes.
Nobody knows.
Yes.
Whatever
Yes.
is the trustee says, it won't be the religious practice.
absolutely not. Absolutely not. We have to show evidence that it has been followed and the customary practices is there. Now, what I realized, Your Ladyship, because I think my instructing counsel just told me that all the documents are in Kannada, unfortunately, and I have to read some of them in detail. While I can translate some of them, I think it may not be fair to Your Ladyship to rely on my translation, everything. So, because I think they just assumed, Your Ladyship, that you will be able to read some Kannada language. I apologize for that. But what I can do is the scheme is in English. I can take Your Ladyship to the scheme, or I can produce all the documents in translated versions and come back before Your Ladyship.
What is any urgency for you?
In fact, the urgency is for us. I mean, my learned friend is more urgent because it is his right that is been intervened, but I am also in some urgency, my ladyship.
So then whenever, next week can you file the, because unless I understand that.
As per imputed order, he is not an accrued person. The
Who?
petitioner, the deputy commissioner already permit him to enter the Garbhagudi whenever his service is necessary.
No, his grievance is you are interfering with his.
My powers of management.
My lord, I will clarify that, my lord, your lordship, for a minimum, my lord. Section 1, my lord, how the act applies, it has stated. Section 1, it shall extend to the whole of the state of Karnataka, it shall come into force and so to so. It shall apply to all religious institutions or charitable endowments notified under section 23, section 53 and chapter 8 shall apply to all religious so and so.
I was a standing counsel for
Provided.
endowments, I was a standing counsel as advocate, standing counsel for endowments for like 7 years, and a standing counsel for TTD for 12 long years. So the entire scheme of the act I know.
Yes. That's why it is applicable to all. They can't say that the act is not applicable to them. They can't say.
No, I'm not saying that, sir. I'm not saying that.
Yes.
I'm making a different point. Yeah.
Custom needs to be registered in a register, usage in custom. There is no such registered as is mandated under the provisions of 97 Act. Nor is it the case that this is.
No, for example, TTD is there.
Yes.
Please.
Every ritual, what should happen, how it should happen. Even in the 1920s and 30s, even a protocol, how it should be followed. If so-and-so comes, how should be it welcome? And what type, the kind of prasadam should be offered to the god. Everything is scripted and everything is a written
Recorded.
this thing. Not only to that temple, majority of the temples, what I have seen, the registers that would contain like who will be what would be the functions, and what are the special days, and in those special days, what is the practice of religious, which agama they follow. Everything would be codified. If it is not, this is how it will be. Now it is like this. What the trustee says is the law.
In fact, Your Ladyship, the point is that there is a certain tradition in Karnataka which broke away from the traditions of rituals. So these temples come from the tradition which believed that the linga actually resides in you. That if you worship even with the tulsi leaf, that the god will favor you. So they moved away from rituals. That is why the agama principles, for example, do not apply to temples like this.
No,
Like
that is
every temple-
incorrect. So far, this
temple-
temple, this statement of senior council is incorrect.
Codified, like what is the practice, so that in future these kind of things will not come once for all. Whatever it is, let's say this is a practice, let's accept it and write it in a written form, so that tomorrow let there be no scope for arbitrariness.
One more interpretation.
It is in the scheme itself. It is in the scheme that was passed in 1920 itself, Your Ladyship. I'll take Your Ladyship through that scheme.
Yes.
When do you want?
Can I request for the request for 19th?
Please.
Yes, 19th.
Meanwhile, I'll have the transfer.
And if those records can be if the government advocate can get the records which Your Ladyship had ordered last time.
All the records, as a
Please,
request
please.
of council petitioner to file the translated copies of the documents, list the matter on 19th. By the time the AAG shall place before all the records pertaining
Temple records also.
pertaining to the
Like,
The order
also, my lord, you may be directed to secure the records.
and also
to
the
get a
order that
translation.
is imputed.
I'll follow that, my lord.
Yes, Mrs. Yes,
Yeah, much obliged.
he is saying something, Mr. Kulkarni.
Unmute ಮಾಡ್ಕೊಳ್ಳಿ.
Yes, next.
Obliged.
Seal number 78. Rishas Maigu.
My lord, short accommodation. Due to the health upset.
It is coming. I represent.
My lord, kindly on short accommodation, my lord. The 8th killer of the senior. He has gone to hospital, my lord.
Request of the council.
My lord, kindly entry motor shall be extended.
Where from the intermodal to be protected? Give it to him. You please extend on your own. Yes, this is my
Please go. GMCBC, my lord. Interior matter is also in Kannada language, my lord. IAWS is all in Kannada language, my lord.
Yes, this is matter after 2 weeks.
My lord, Interior matter, my lord.
Is there?
Is there? Is there?
Extended till the next date of hearing.
Please.
Yes, 80.
Seal number 80 urgent. Seal number 81. Santosh Kumar B.
No
GV
representation.
Dharmagowda.
No representation after 4 weeks.
4 weeks.
Yes.
Seal number 82. Shivraj.
Lord, appeal to
Mahanteshwar
the
Patil.
petition, Lord. This is yesterday's matter, my lord. The appeal was, my lord, against the original order passed under section 68. Appeal was filed under section 106 of, my lord, the Karnataka Cooperative Societies Act. And IA was filed for grant of stay.
Yes.
Please.
We'll set aside this order and
Please,
let,
please.
giving opportunity to
Please.
both the parties.
Please.
The present
May I make
petition
one
is
more,
filed.
one submission, one humble submission, my lord. Lordship may kindly see page number 65, my lord.
page number 65, my lord.
Yes.
This 65, my lord, the appellate authority, my lord, allowed the, my lord, IA number 1. It is
That's
for,
what-
it is for, my lord, delay, my lord, and dismisses the IA number 2, my lord. Humble submission is, my lord, it is a writ petition is under Article 226, my lord. Even the authorities have not given any reasons, my lord, while allowing IA number 1
No,
also.
they have not challenged. No, they have not.
Yes, yes,
Can it be
I have
in
not
his
challenged
repetition? No, he files a repetition for some other prayer, will set aside the order in his favor.
Because
Yes, that
there
you
is
should
no,
have come before the
there
court.
is
You have
no
not come.
reasons.
The present repetition is filed about seeking the following prayer. The facts of the case are: the fourth respondent is a cooperative society registered in the provisions of the Karnataka Cooperative Societies Act, and the petitioner was appointed to the post of chief executive. Since then, he has been discharging his duties satisfactorily. An inquiry under section 64 of the Act was initiated with the competent authority by appointing the fourth respondent as an inquiry officer for holding an inquiry under section 64 of the Act. It is a case of the petitioner that the fourth respondent has not served the notice, not heard the petitioner. No statement of the petitioner was recorded. Inquiry proceedings were initiated behind the back of the petitioner without providing an opportunity. An inquiry was conducted and an order was passed on 4/9/2024. The petitioner has passed an order on 11/11/2024. Then the petitioner has carried this before the second respondent. And before the second respondent, he has filed 2 IAs. One is to condone the delay, and the second is seeking stay of all, seeking a stay. It is a grievance of the petitioner that the second respondent herein has allowed IA number 1 and condoned the delay in filing the appeal, but however rejected IA number 2 seeking stay. It is submitted that this order is passed under 106 or 3.
106, please. 106 applause.
While exercising an appeal under
6.
106, when he is passing an order, the order should contain the reasons. It is submitted that no reasons are assigned why the is not entertaining the stay application filed by the petitioner. It is submitted that as the same as bereft of reasons, on that ground, it has to be set aside. When counsel appearing for the respondent submits that when it comes to condonation of the delay, without reasons it is condoned. So the petitioner, the petitioner cannot find fault with an order where the stay petition is rejected without reasons. In response to, and there is no, it is submitted that no interference is called for. In response to that, then counsel the petitioner submits that the petitioner is not, if the petition is agreed with the order of condoning the delay, and in that he can raise all these grounds that is not available to him in the writ petition filed by the petitioner. Next, having heard so and so. There is no dispute about the fact that while entertaining appeal under 106, 2 applications are filed. That is IA number 1, IA number 2, 1 for condonation of delay, 2 for the stay. Delay was condoned, however stay was not granted. When the stay petition was filed, while rejecting the stay petition, the second respondent ought to have given cogent reasons for such rejection. Without that, the order impugned. Without that, the second respondent has mechanically has passed an order dismissing the stay petition that cannot withstand the legal scrutiny, and every order, the reasoning is a heartbeat of any order. In that view of the matter, the order dated so and so is set aside, and the second respondent shall order is accordingly. This court is passing the following order: the order dated so and so is set aside, and the second respondent shall consider the IA number 2 afresh by giving reasonable opportunity to both the parties. Accordingly disposed.
Disposed.
Yes, next.
Password matters.
Which is the first password?
Your Lordship,
Number
Yes, matter
Password matters, number 9.
81, Mother.
81. Elections are over, my lord. Chief Executive Officer, my lord, will come and say, my lord, file wakalat.
Serial number
81.
67.
Elections are over.
Matter
81, your lordship. 81, your lordship, you kindly have it on Friday, can be disposed.
81.
81, please.
81 list on
Friday. Friday,
possible, if Thursday or Monday.
please. Thursday,
Yes, Thursday.
please. Obliged.
Yes, 19.
Passport matter, stone 19, serial number.
What is this?
So this is the cancellation of tender, Your Honor, by the city corporation. The city corporation has cancelled the tender basing upon the official note, Annexure A, madam. If you peruse the,
No, they do not want to go ahead with the tender process, that is question.
yes, ma'am, I have challenged this notification, note.
Who are
So-
you? Who are you?
I am the petitioner, I am the lowest bidder in the, this tender, Your Honor.
No, as per the tender conditions, there would be a clause saying that without assigning the reasons, they reserve the liberty to cancel the tender notification.
They have cancelled based on one, that Libra Management Science Private Limited.
Let us see the note. Please come to that. What does it say?
It is.
The note which you are questioning,
Yes, ma'am.
endorsement, please.
I will read it, ma'am. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೆಳಗಾವಿ ಮಹಾನಗರ ಪಾಲಿಕೆ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್, ಅಕೌಂಟ್ಸ್ ಕನ್ಸಲ್ಟೆಂಟ್ ಅಂಡ್ ಜೂನಿಯರ್ ಪ್ರೋಗ್ರಾಮರ್ ಇವರನ್ನು ಪಡೆದುಕೊಳ್ಳಲು ಟೆಂಡರ್ ಕರೆಯಲಾಗಿತ್ತು. ಅದರಂತೆ ಸದರಿ ಟೆಂಡರ್ನಲ್ಲಿ ಭಾಗವಹಿಸಿದ ಲಿಬ್ರಾ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಸೈನ್ಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಇವರು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ನಲ್ಲಿ ಅಟ್ಯಾಚ್ ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿಯವರು ಸಲ್ಲಿಸಿದ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪರಿಶೀಲಿಸಿ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ತಾಂತ್ರಿಕ ಅಡಚಣೆ ಉಂಟಾದಲ್ಲಿ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಆದೇಶಯುಕ್ತ ಸದರಿ ಟೆಂಡರ್ ಅನ್ನು ರದ್ದುಪಡಿಸಲು ಹಾಗೂ ಮರು ಟೆಂಡರ್ ಕರೆಯಲು ಮಾನ್ಯರ ಅನುಮೋದನೆ ಕೋರಿ ಸಲ್ಲಿಸಿದೆ.
What does it mean?
It means, ma'am, they have falsely attached in other.
What is that?
Well, what had happened is, one Libra was management was the one of the bidder. Certain documents they had attached which were not reflected in the portal at the time of evaluation. We rejected their bid based on the non-furnishing of those documents. Subsequently, they approached us. They pointed out the deficiency, and we verified. They had attached all those documents. Since we had rejected, we ought not to have rejected their bid. So, we cancelled it. We have called a fresh tender.
Cancel it again, you can consider.
I'm sorry,
You can again consider.
in the what I was told is that it was at the stage of financial bid, opening stage. So we cannot let them in at that stage. So we called cancelled it and we called a fresh tender. Other aspects have not been put forth before this honorable court is that in the fresh tender, petitioner has already participated. That has not been mentioned here.
By the time writ petition is filed, he participated. By the time the writ petition is filed, he already participated in the.
Yes, my lords. Yes.
Not stated in this petition.
Nowhere it is stated.
When was the second tender called for?
My lords, on 17
17/10/2025.
17/10/2025. When is this writ petition filed?
21/2025.
Did you say so, that you participated in the tender?
No, Your Honor, the information has not been given.
You means your client ought to have informed this to you. It amounts to suppression.
Now what has happened is, my lords, financial bid, there are 3 bidders, all are L1. My lords, through lottery, since all are L1, we are going to elect through
Quoted the same price.
same price. So we are going to select by lottery system as per the tender condition.
Only they are favoring one, that Libra Management Science. They have, this is the third time they have called the tender.
Better not argue more on that, for the reason you have participated and your case is under consideration. Yes, please come. Agreed with the present writ petition is filed, seeking the following prayer. The facts of the case are: petitioner is providing the security and allied services to various agencies and government offices in the name of Guru Basav Security and Allied Services. The respondents on 24/6/2025 had called for the tender for supply of data entry operators, account consultants, and junior programmers on outsourced contract basis to attend the office work at City Corporation, Belgavi. The petitioner has submitted his financial proposal for selection of tender for the tender by depositing earnest money of rupees 3 lakhs. And the bid of the petitioner was the lowest among all the bidders. It is a grievance of the petitioner that on 15/10/2025, the respondents has cancelled the tender based on official note without assigning the valid and cogent reasons. And it is stated that on 17/10/2025, the respondents have again called the retender. According to the petitioner, the impure note of the respondent is strongly objectionable and against the norms. The respondent has rejected the bid of the Libra Management Services Private Limited and opened the bid of the petitioner and another person. And among the two, the bid of the petitioner was the lowest. The fact also discarded by the respondent only to benefit the Libra Management Services. It is a grievance of the petitioner that only to facilitate the Libra Management Services, the tender is cancelled. Land Council appearing for the first respondent corporation. The first respondent corporation submits that when it's a fact that they issued the tender notification and pursuant thereto, the petitioner and two others have participated. And in that, as they have disqualified the Libra Management Services on the ground that certain documents are not uploaded. And after verification, they found that they have uploaded all the documents, but as the same was not, as they couldn't find it, they have rejected, considering the mistake that is committed by the respondent corporation. And at that point of time, as they cannot permit the said Libra Management Services to continue for the tender process from there, they've cancelled the tender and floated the second one tender notification on 17/10/2025. Land Council submits that the petition has come before this court with suppression of facts. The writ petition is filed on 21/2026, and by the time the petitioner has participated in the tender, and all the three participants have quoted the similar price, and as such, then now they are going to, what are you going to do?
Lottery, as per tender condition, they will choose by lottery system.
As per the tender condition, when there is a exigency of this nature, they would select the tender by way of lottery. Now they are in the process of that. It is submitted that the writ petition has to be dismissed on the ground that the petitioner has come before the court with suppression of material facts. Next, Land Council appearing for the petitioner, having heard the counsels on either side, peruse the material on record. First and foremost, if in the tender conditions, there is a clause that without any reasons, the respondents are at liberty to cancel the tender. That apart, the reasons that are stated with the Land Council for the respondents are the reasons on which they have floated the second tender. The petitioner, having participated in the same and having been shortlisted, he ought to have come before this court by filing this writ petition and ought not to have suppressed the material facts. In that view of the matter, this court do not find any reasons to interfere. Accordingly dismissed.
Please.
Please next.
Seal number 20. Sinan Arvind Pachapure.
Defendant
20.
force writ petition.
Sunilas Desai.
Lord, I appear. It's the defendant force writ petition minutes challenging the orders on I number 11 and 12 minutes. I number 11 is for minutes reopening of the evidence of DW1 minutes.
You are the
Of the evidence.
The plaintiff.
No, defendant. my lords.
Co-defendant.
The only question here is, my lords, whether a defendant can cross-examine the co-defendant. On that point, my lords, the court rejects, my lords, stating that plaintiff has already led his evidence. At length, cross-examination is conducted. Therefore, the question of again defendant cross-examining the co-defendant does suit for recovery of money.
Who are the defendants?
Defend the plaintiff and this present petitioner, defendant number 4, are husband and wife. Plaintiff, my lords, she, in her name, there is a enterprises, firm, my lords, proprietor firm, my lords. She had lent the machines for iron ore, my lords, for mining of iron ores, my lords, to the defendant number 4, my lords, who in turn was to export the iron ore to defendant number 1 company.
Number 4 is none other than the husband.
Husband.
Defendant number 1 is
Defendant one, the company.
Company,
Defendant
it is
number
a
1 and 2 are the company.
represented by whom?
By, my lords, it's a MSPL company.
There is no nexus between the
No.
defendant number 4 and 1 company.
No.
No. In fact, my lords, there was earlier, there was a recovery suit filed against this petitioner, my lords, by defendant number 1, when we had admitted that this much amount was required to be paid. 4 crores was required to be paid. And we are ready to.
Defendant number 1 has filed a suit against defendant number 4.
Yes, that has ended, my lords, in compromise, I feel.
No. It is a decree. Suit decree is
Now, which defendant wants to examine the which?
defend number 4, husband who lost a suit against defend number 1 to 3. Now in the suit of his wife want to cross-examine us.
Wife suit is?
Wife suit is
For
recovery
recovery.
against defend number 1 to 3.
Recovery.
Recovery against us.
They have
Recovery
taken a
against us.
specific contention at para 8 and 9 of their written statement. There are averments against this defendant, stating that earlier you were there in that suit and you had admitted the amount, you had sent.
Let's see the order.
Yes. Page 18, my lords, reasons.
Page?
18.
Para number 7, my lord, is to be.
Let's read the reasoning part.
Yes,
Please.
that.
And what are the facts?
Yes.
May I read it? Yes. The plaintiff, para 5 minutes, please. The plaintiff has filed the suit against the defendant for the relief of recovery of higher charges. In this case, defendant 1, 2 have filed written statement by resisting this suit. Thereafter, the issues were framed and the plaintiff completed her side evidence. Defendant number 1 completed the evidence. The representative of defendant number 1 company, S. Basaraju, examined as DW1. When the case stood for arguments, the instant applications have come to be filed by defendant number 4. By filing the said application, he wants the court to reopen the stage for arguments and to recall DW1 for purpose of cross-examination. As I said, these applications are opposed by defendant number 1, having regard to the contentions taken by him in their objections. It is to be decided whether the application deserves to be allowed or not. Defendant number 1 submitted in their objections that these applications are not supported by the affidavits of the defendants number 4, and contended that defendant number 4 is none other than the husband of plaintiff, and he has no rival claim against this defendant number 1, and he has admitted the averments of the plaintiff. Further, the plaintiff counsel has cross-examined DW1 at length, covering all the.
Defendant number 4 has filed his written statement accepting all the contentions.
And
of the
supporting the plaint and declaring this plaint.
But he has nothing independently to
Nothing independently.
No, if my lords, if the defendant number 1 makes an averment against defendant number 4 in respect of the earlier suit and, my lords, the transactions, because here, my lords, the firm was in the name of wife and the vehicles were in the name of wife.
Understood.
Yes. So therefore, my lords, now tomorrow, my lords, at the time after the trial, my lords,
What are you going to prove? The plaint, she has filed the plaint. You filed a written statement accepting all the contentions that are raised in the, it is nothing you have not, there is no burden on you because you have not denied anything. So why should you cross-examine the defendant?
no, that is the reason that, my lords,
He is doing it.
your lordship may see, my lord, their written statement, para 8 and 9. That's the only thing, my lords, why I want to cross-examine defendant number 1.
No, whatever it is for the plaintiff to prove against the defendant.
True.
As far as defendant number 4 is concerned, you are sailing with plaintiff. So she will not, there is nothing between you and the plaintiff. And what is your role to prove anything against DW, defendant 1 to 3?
No, if, my lords, if in the evidence now which has been led, my lords, by DW1.
Nothing much is
One clarification.
No, let's take your lordship to the evidence of DW1.
That is fundamentally, let's not go into the facts. On a fundamental aspect, you have nothing to prove. Come to paragraph number 7.
Yes, please. Further, the plaintiff counsel has cross-examined DW1 at length, covering all the contents raised by the plaintiff and fourth defendant. As such, again, cross-examine DW1 by this defendant is not required. If this defendant, having raised any claim against this defendant independently, then the question of cross-examination of DW. No, but this issue was already raised. Not there. What they took the defense is.
Let us say there is an issue to be decided. It is not for you. It is for the plaintiff to prove. You are not, neither you are going to gain by this or lose against this. This is only the plaintiff who will take, but anyhow, support her in all other ways, but not as a defendant. Agreed with the orders passed in I number. This is I number?
I number 11 and 12.
10 and 11.
10
and 11, Miller.
I number 11 is allowed, so it's only I number 12.
No, both have been rejected.
Both are rejected.
Both
I number 10 and 11.
Agreed with the orders passed in I number
11 and 12.
In OS number 72 of 2018.
We'll read 11 and 12. 11 and 12.
Dated 21/20/26.
11 and
The defendant number 4 is before this court. The respondent number 1 now is a plaintiff.
Please. Respondent number 1 is the plaintiff.
Respondent number 1 has filed the suit against the defendant number 1 to 3 and also the petitioner defendant number 4. Defendant number 1, defendant number 4 is none other than the husband of plaintiff number 1.
Plaintiff only.
Plaintiff. The suit is filed for recovery of higher expenses. Recovery of higher expenses. When she has filed the plaint, the defendants 1 to 3 have filed the written statement and defendant number 4 has supported the case of the plaintiff. Thereafter, the suit, when the matter is posted for
argument
of the defendants,
plaintiffs,
plaintiff, at that point of time, these two applications were filed, I number 11 and 12. I number 11 was filed under order 18 rule 17 and related to section 151 CPC, praying the court to reopen the case from the stage of arguments and to recall DW1 for the purpose of cross-examination. That is both the to cross-examination. That application came to be dismissed by way of impugned order. The court observed that the plaintiff's counsel has cross-examined DW1 at length, covering all contentions raised by the plaintiff and 4 defendants. As such, again, cross-examining DW1 by the defendant is not required. If the defendant having raised any claim against the defendant independently, then the question of cross-examination of DW1 would arise. But as noted, he has completely admitted the case of the plaintiff as a witness to the plaintiff's case. As such, applications are deserved to be dismissed and accordingly dismissed. Learned counsel appearing for the defendant 4 submits that the court ought to have allowed the defendant to cross-examine defendant number 1 to 3. It is submitted that there was an earlier suit, there was an averment with regard to the earlier suit, which was decreed, and regarding those averments, the defendant number 4 wants to cross-examine the other defendants. The court, without properly appreciating the contentions that are raised by the petitioner defendant, has dismissed the same. Learned counsel appearing for the defendant number 1 to 3 submits that the court had rightly considered the fact that the plaintiff and the defendant number 4 are sailing with each other, and the plaintiff has already cross-examined the defendant and the defendant has no independent claim against the defendant 1 to 3. As such, the cross-examining the defendants is not required, and the court had rightly considered and passed orders having heard the counsels on either side. There is a material on record. There is no dispute about the facts that the suit is filed by the plaintiff. Again, the suit is filed for recovery of fire charges against defendants 1 to 4. 1 to 3 is a company. 4 is the husband. Both the husband and wife are sailing. Husband has no independent claim, that is defendant number 4 against defendant 1 to 3. In that case, whatever are the reasons, there is no necessity to, for the D4 to cross-examine D1. When D4 has no independent claim against the, one D1 to D3, that is the lookout of the plaintiff, and plaintiff has already cross-examined at length. In these facts and circumstances, the court has rightly dismissed I number 10 and 11, and this court do not find any reasons to interpret. Accordingly dismissed. Yes, next.
Please.
Seal number 27,
Yes.
password matter.
Your Lordship, this is covered, Your Lordship, where interim order can be granted, Your Lordship.
Then counsel appearing for the petitioner submits that the petitioner has questioned
Striking of
the clause 2, 1B,
of section 2D1.
huh?
Of section 2(1)B
of the,
of Karnataka.
what is that? Karnataka?
Karnataka Sugar Orders 2022, regulation and
Yes,
of.
I question the sugar or the Karnataka Sugar Order 2022. It is submitted that similar repetition.
Slight correction, my Lord. Karnataka Sugar Regulation of Production Order.
Into bracket.
Into brackets. Karnataka Sugar.
And when in similar matters, the coordinate benches of this court have granted the interim orders, and the main writ petitions are pending consideration. He has placed before the court the similar orders. Learned HCGP appearing for the respondent submits that this is also covered by the said orders. Accordingly, in the light of the order passed in WP number 106594 of 2025, this court is passing the following order. This is at page 126, same order. List along with so and so.
Please.
Please.
Yes, next.
In that one submission, 1 to 3 state, my Lord.
HCGP takes
4 is the
respondent
KL
1 to 3.
1T for R4.
Notice?
Notice to R4 standing counsel is there, no?
What is the name?
LM 1T.
So and so is directed to take notice on behalf of R4. Petitions are the copies on all the councils.
Please.
Yes. Next.
Along, number is good. Seal number 54, password matter 54. J. Shetty.
Petitioner,
AS Party.
like my lord, most of the documents are in Kannada. I am getting it translated, my lord, on 2 days. Even the order passed by the court, my
Last
lord,
occasion matter was heard, my lord.
order passed by the trial
And,
court is also, my lord.
They are enjoying the order of status quo. By taking advantage, my lord, in the field, they are interfering with my possession.
My lord,
Is it necessary that
yes,
we
my
need
lord.
to
In
look
fact,
at
my
all the
lord, the trial
documents?
court order is itself is in Kannada. That's the problem.
When this matter has come up before me, do the order sheet.
The question was, my lord, whether the.
My lord, in fact, my lord, I will argue. My
List
lord,
this matter on 10/2/2026. It
yes.
is made clear that no further adjournments will be
Yes,
granted.
my lord, in fact-
This order is on 5/2/2026.
Yes, my lord. So far as, my lord, I am concerned, my lord, we have purchased the property in the year 19.
Not going to the merits of
Yes,
the matter. I'm
yes.
talking about your adjournment.
Yes,
Now you
not
should
that,
have,
my lord.
if it is the impugned order is in Kannada by this time, you
Yes.
should have filed the translated
We
copy.
are trying to, my lord, but the large bulky documents are there.
How many pages? Let's see.
But it's the documents, my lord, it's about, my lord.
So not required at this, for while hearing a matter under 226.
Yes, my lord, in fact,
Where is that?
annexure, yep. Page number
No, your question, an
Seven-
order passed in MA.
MA.
Then why? do you-
MA, my lord, because the trial court, my lord, correctly assessed the, my lord, both the respective documents of the
Of
party.
hearing and counsel for the petition shall place on record the translated copy of the order passed in IA in the suit.
Yes.
If the same is not placed before the court, whatever the court understands will pass an order.
That's you want to, my lord, convince the court not to confuse. actually.
If the same is not placed before the court, the stay will be vacated.
Please.
This matter on 19th of February.
Interim order.
Interim order earlier granted is extended till then.
Obliged.
Seal number 57.
Yes.
I appear for the
Yes, Sadiq Kanvi.
I appear for the petitioner, my lords, who is the plaintiff number 17, my lords, in the OS.
You have to briefly state that time you argued at length. Now you straight away come to the
Yes,
point.
my lords.
What it is.
My lords, your lordships had raised a doubt with respect to, my lords, the order, my lords, that is page number, my lords, 29, my lords, where your lordship stated that, my lords, that criminal miscellaneous in 2018 you had filed a criminal miscellaneous and the same was at your knowledge in.
It's an amendment petition you have filed, it's
Yes.
dismissed.
Yes, my lords.
Suit is of which year?
2010, my lords.
Suit is of the year 2010.
2010.
Now you filed this IA when? Which year?
2025, my lords, in the seventh month of 2025.
7th month of 2025. Now
Yes.
let's look at your affidavit.
My lords, my amendment, my lords.
IA that is filed.
Yes, my lords.
Hmm. Give us
IA
the
that
file.
is filed is in page number 125, my lords.
120.
125. My lords, the reason for my amendment is, my lords, in the cross-examination, she has elicited as to how the misrepresentation and fraud has happened. And the same is placed on record also as per Annexure E, my lords.
Please tell me.
Yes, my lords.
If anything like during the course of evidence, if the defendant says something, basing on that plaintiff will amend the.
No, my lords, my lords,
letters-
my lords,
plaintiff.
I'll convince your lordships on that point. My lords. I'm not covering up my, the, whatever I've said in the cross-examination or whatever for that matter, my lords. The only thing, my lords, I've already stated that there is misrepresentation and fraud in my plaint. And based on the same, there is an issue also framed that I have to prove that there is misrepresentation and
What is the
fraud.
stage of the suit now?
It was filed at the time of final argument, my lords. This IA was filed at the time of final argument.
Lords.
Again, it is final argument, my
My
lords.
lords, I'll convince your lordships. My lords, the reason why it was,
When was the cross?
my lords,
When was the cross?
my lords, cross-examination, my lords, that is also in the 7th.
On 16th November 2024,
My lords,
the council who is seeking amendment has solved this particular question in the month
My
of
lords,
November
if-
2024. After 5 months from cross-examining.
No, my lords, I'll
Kindly peruse page number.
my lords, if I may be permitted to submit, my lords. From 21/9/2024, my lords, the cross-examination, my lords, went on till, my lords, on 4/2/2025, my lords. And then, my lords, in the 6th month, my lords, I have filed an IA. In the 7th month, there is a dismissal of the IA. All that I want to seek, my lords, is in the plaint, there is a paragraph with respect to fraud and misrepresentation. There is an issue with respect to fraud and misrepresentation. And, my lords, on the same thing, my lords, I'm not going to change the nature. Nothing is going to change. Only the thing that has been brought out here in the amendment is how the fraud and misrepresentation has happened. With respect to that, I filed an IA. And
What will happen if you don't file now?
my lords, the thing is,
No, now you have filed. What will you do now?
my lords, I'll not, my lords, I undertake, my lords, that only what I want to put across is para number, whatever is stated in the amendment application, only that I want to bring it to the notice of the court. Further, I will not cross, neither I will do chief examination.
No, if she said something that is there on record.
No, my lords.
Her cross-examination is there on record.
Yes, my lords, her cross-examination is there on record, my lords.
No, to the 2020 suit, it will not be kept pending for not even a month now. I will ask them to dispose it off within a month. Please come.
Yes, my lords.
Agreed with the orders passed.
My lords, I want to argue on merits, my lords.
No, merits you have argued. What else you want me
My
to
lords,
hear?
there is still, pardon me, my lords, I still want to argue on
I
merits.
think you better file your written arguments. I'll pass the order. Because I heard, I can't hear you.
My
more
lords,
than
no,
this.
my lords, there is only,
The land counsel for the, let him file the written arguments by tomorrow. I'll pass the orders by day after tomorrow. This thing will be uploaded. Dismissed.
my lords, please, my lords, on Friday, my lords, I'll file written arguments, my lords. My lords, because one small point, my lords, I'll bring your lordship to the notice of your lordships, my lords. In the
No, I'll do one. Now you file your written arguments. I'll give you one more day, but that day I will dismiss it with cause. If it is today, I will dismiss it as it is.
my lords, pardon me, my lords,
Yes, we'll
once,
take list this matter on Thursday. By the time the land council shall file the written arguments, in the court I will pass the order.
My lords, one short point, my lords.
That you can tell in your written arguments. I understood what is your, what point you are saying. From the last two occasions you are
No,
arguing.
no, my lords, no, my lords. That with respect to the point that in criminal miscellaneous of 2018, I had filed.
Mr. Counsel, I said you file your written arguments. That will be more easy for me. I'll hear it and pass orders in the court. I'll look at it and pass orders. But I'm telling you that it's going to be with cause for a suit of 2010.
My lords,
Yes, next.
My lord, serial number 58.
till then interim order may be extended, my lords.
The interim order will be extended, don't worry. Yes. Serial number
58, pass or met.
58.
I appear for the respondents 1 to 3. my lord.
Yes.
Lord, this is the defendant's writ petition, divergent findings on injunction. Lord, trial court, my lord, had refused to grant, refused to grant an order of injunction. Appellate court, my lord, has granted an order of injunction.
What is the suit for?
Suit for injunction.
Bare
My lord,
injunction.
bare injunction. My lord, the case put forth by the plaintiff is, they have purchased the property in 2025. And my lord, we are disturbing the peaceful possession of their possession. This is a simple case. Our case is from 1917, we are in possession. Subsequently, we had filed form number 7 before the land tribunal. In the meantime, my lord, the land had been converted in 1955 into non-agricultural purpose, but it remained to be an agricultural land. That was the case, and subsequently, the land tribunal had conducted a spot inspection. In the spot inspection, it is held, it is shown that the petitioners are in possession to the extent of 3 to 4 acres, and the other defendant number 6 is in possession to the extent of 2.5 acres. Hence, my lord, and the land tribunal rejected on the ground that the land had been converted into non-agricultural purpose. Hence, my lord, in the after rejection of the form number 7, there is no proceedings as such which are taken place to evict the petitioners. My simple case is, since my lord, the land tribunal had my lord, conducted the spot inspection, and my lord, recorded that we are in possession to the property, and the plaintiff.
The order of the land homestead.
My lord, I have translated, last time I had taken time, my lord, to produce a translated copy.
Please tell the date.
Well, 94.
1990.
94. My lord, it is not the case of both the parties that, my lord, between 94 to till 2025, some proceedings had taken place even after rejection of form 7 Tahsildar. Pardon?
Defendants, how many are in number?
4, my lord. 4, 5. They belong to the same family.
You are representing all of them.
Yes. So in the facts and circumstances, well, my lord, the divergent findings, my lord, have been recorded.
Let's look at the appellate.
Yes,
Come from the read from the reasoning part.
please. Lord, page 35, my lord, reason starts.
Come to 52.
I'm sorry. 52.
Yes, paragraph number 11.
Please. On careful appreciation of material on record, before the trial court, plaintiffs have filed a suit for permanent injunction against the defendant in respect of the suit schedule property, in which, by filing IA number 1 under Order 39, Rule 1 and 2 of CPC, have sought for interim temporary injunction order by restraining the defendants from obstructing the plaintiff's peaceful possession, so and so, enjoyment of the suit property till disposal of the suit. Accordingly, by considering the trial court has rejected the interim order respect to the suit property through order dated 25 to 2025. After perusal of the documentary evidence, including the pleadings placed by both the parties, if it reveals that the suit property is originally owned by so-and-so, and he is having the continuous title over the suit property, it is the case of the respondents that though oral agreement held in 1924, they are in possession of the suit property. After appearing before the trial court in OS number so-and-so, they produce the material documents except photographs with respect to the suit property. Further, there is no such relevant document produced by the defendants to show the alleged oral agreement held with the original owner in the year 1924. The plaintiffs have legal ownership and possession with respect to the suit property On the strength of a registered sale deed, defendants claim their continuous possession on the oral agreement alleged to be held in the year 1924. Hence, the registered sale deed prevails over the oral agreement. As per the TP Act and the Registration Act, title of the immovable property can only pass through the registered instrument. There is no document from the defendant seeking specific performance since 1924 till today. Hence, the alleged possession, unless protected under Section 53A of TP Act, under the concept of the doctrine of the part performance, since 1957, there is a mention of any land in the revenue records. Hence, the alleged agricultural activity of the defendants may itself appears doubtful. Hence, the plaintiffs, by holding registered sale deed, they have proved how they are connected to suit property. Hence, though oral agreement, defendants cannot defeat the plaintiff's title possession of the suit property. The title passes only to the registered instrument. Oral agreement registered agreement confer ownership. Defendants ownership without written instrument cannot defeat the registered instrument of the plaintiffs. Revenue entries or cultivation records over the NA land do not override the ownership under the registered sale deed. Defendants are not entitled for interim injunction itself based on the oral agreement. Hence, the plaintiffs are protected under the registered sale deed and they are entitled to.
You have not placed any document to show that you are in possession of the property.
Milord, we had produced, Milord, the trial court finding is we had produced the records like electricity bills and Milord, the photographs showing that we are in possession of the, that is the finding.
The writ petitions, that is all way back in the year 1994. In all the writ petitions, no.
Milord, the recent, the materials that are placed before the trial court are of the recent years of the two.
The material, what is that it is filed?
Milord, may I take my lords to the finding of the trial court for a minute, Milord?
No, always I find these orders. Now, some material is placed before the court. It should be part of the annexure.
Since
in
Milord,
IAS also.
quite so. Milord, since I came subsequent to in the writ petition.
But none of the cases the courts are doing it. No, we don't understand what are the documents that are filed. You will be filing some documents.
Milord, may I place on record all those documents that I had produced along with Milord, may I request?
No, you can place the document to show that you are in possession of the property as on the date of the suit.
Yes, ma'am.
Sure, you can help to have.
Milord, apart from the,
They have been placed before the trial court.
yes, ma'am. Milord, the finding recorded by the trial court based on those documents itself. The trial court records finding on those documents. Yes,
Go to that
Milord, may I request page 69, Milord, directly.
Yes, please come to that.
Para 22, Milord.
Yes, in support of.
In support of IA, plaintiffs produce the following documents: photograph, notice, FIR, so and so, way out of the land, and so, and temporary injunction. In support of IA, defendants have produced the following documents: RTC, requisition of supply of the electricity, tax paid receipts, electricity bill, objection regarding registration of sale deeds, photos. From the above, going through the allegations from both the sides, so and so, the para 25, Milord. The plaintiffs assert that they possess the documents supporting their claims. At this juncture, it is essential to examine the presumption established under Karnataka Land Revenue Act, according to Section 133 of the Act, which addresses the presumption concerning entries in the official records as an entry of the record of rights.
Which are those documents in support of your IA number?
Some of the documents, Milord, have been produced along with the as a copy of the writ petition.
Where are they?
Milord,
To show that as on the date of filing of the suit,
Milord,
you are in occupation of the land.
may I request page 92, Milord? This is one of the electricity bills.
Page number?
92, Milord. 92 electricity bill for the 18/8/2025, 18/8/2025, and 18/5/2.
You're referring to 92.
Yes, Milord. I said 92, 93.
Statement of objection, they are referring to writ petition. That may be my statement of objection. They are referring to.
I'm looking at the objection.
They have annexed it in page number 92 of their writ petition.
Writ petition. Writ petition.
That has been compiled together, my lord, so that's why.
90?
92.
Writ petition.
This is pertaining to?
Milord, dated 18/8/2025, bottom of the page, my lord.
6/5/2025.
25, then 18/8/2025, then 18/5/2025.
What is the finding of the court on this?
Well, the appellate court says, since there is a registered, if one registered document is pitted against the oral agreement between the parties, the
What are you doing in that
my lord,
place?
agricultural activity, my lord. Agricultural activity. Photographs, my lord, there are subsequent photographs. Page 102, 103.
Yes, we'll hear the senior counsel. Yes, Mr. Senior Counsel. It's muted.
Sir, unmute, sir.
Your Lordship may kindly take the statement of objection. In that annexure R4 at page 65. These petitioners had filed application in Form 7 claiming occupancy right on the ground that they are the tenants. Your Lordship may kindly go to page 70, paragraph 6.
Yes.
In the instant case, their application was rejected, they had filed the writ petition. In the instant case, no such records have been produced by the petitioners to prove that they were lawfully cultivating the said lands as tenants. Tribunal has also in detail discussed about the non-production of documents by the petitioners to prove their occupancy right. The record of rights contained in the file discloses that one Gyanoba Gopal, the owner of the land, is personally cultivating the land from the year 95-96 till today. Therefore, any observation made by one of the member of the land tribunal after making spot inspection to grant land in favor of the petitioners is not binding on other members. The majority of the members of the tribunal have come to the right conclusion that the petitioners were not cultivating the said land. Therefore, the impugned order under challenge passed by the tribunal as well is a well-reasoned order by relying on the documents produced by R5 to show that petitioners never cultivated this land. Hence, the petition deserves to be dismissed and writ petition is dismissed. It is tribunal recorded a finding they are not in possession, they are not cultivating the property. Then they took up the matter in writ petition. Writ petition, it is confirmed. Their sole argument was in a spot inspection, one of the member has recorded a reason that they have some they are cultivating the land or that they have huts in that land. Then, my lord, in the MEA order, trial court order, your lordship may kindly see. It is not that on these documents anything of this sort is done. Page number 36 in the writ petition.
Yes.
MEA order, page 36, para 12. After perusal of the documentary evidence, including pleadings placed by both the parties, it reveals that suit property is originally owned by one Gyanoba Gopal Mirashi. He is having continuous title over property. It is the case of respondents that through oral agreement held in 1924, they are in possession of the property. After appearing before the trial court in OS so and so, they produced no material document except the photos with respect to the suit property. Further, there is no such relevant document produced by the defendants to show that alleged agreement held alleged oral agreement held with the original owner in 1924. Plaintiffs have legal ownership and possession with respect to suit schedule property on the strength of registered sale deed. Defendants claim their continuous possession on oral agreement alleged to be of the year 1924. Hence, registered sale deed prevails over this oral agreement. As per TP Act and Registration Act, title of immovable property only can pass through registry instrument. There is no document from the defendant seeking specific performance since 1924 till today. Hence, the alleged possession, unless protected under 53A of the Act, under the concept of doctrine of performance. Since 1957, there is mention of NA land in the revenue records. Hence, alleged agricultural activity of the defendants may itself appears doubtful. Hence, the plaintiffs are by holding registered sale deed, they have proved they are connected with the suit schedule property.
What do you say about the electricity bill?
Electricity bill, it is our case. Earlier order, your lordship may kindly see. In the neighboring property, he has his residence and of his land. It pertains to those property.
You're denying that
and there was
they do
that
not
is not
suit land.
And he has encroached a small extent of about 30-40 site, 3 sites of 30-40 in this land where he has put up small thatched hut construction. Last time the court asked whether you are ready to leave that portion. We said yes, instead of litigation, but they are not agreeable. Therefore, lordship may kindly say on what material they prove it.
Yes, heard, reserved.
In fact, the court had suggested to them.
Yes. Yes, Mr. Senior.
Therefore, my respectful submission is,
I'll pass.
It's not a order under MA is a well-reasoned order, no reason to interfere.
Yes, yes. Yes, next. Done. How many are there?
3 men. 4.
Yes.
Seal number 59. Subhash Jagpati.
50.
I am for the petitioner. I am for the petitioner, ma'am.
What is this?
My lord, I am seeking the quashing of the impugned order passed by on I number 9.
We'll have it some other day.
Next.
We'll have it some other day.
Please, my lord.
We'll have it some other day.
Some other day. Yes.
List it
Day after tomorrow.
Day after tomorrow.
No.
Yeah.
Yeah. I have to go next week.
Tuesday.
Next week.
Next week, Tuesday.
Next Tuesday, 7.
Yes.
Please.
Number 63. Passport matter 63.
Or by judgment, passport method. He has approached the same court.
Gurdeva Gachin Mat.
My lords,
Yes,
this is a
for
matter
passport.
where, my lords, the petitioner is a doctor, my lords, and his wife is also a doctor. He has applied, my lords, for renewal of his passport. That application, my lords, came to be rejected by the passport authorities on the ground that, my lords, there are 2 criminal cases which are pending against him. These 2 criminal cases, my lords, have been initiated by sister-in-law of the doctor. There are 2 brothers.
CC is filed.
Please,
CC is filed.
CC is filed.
So when you can go before the court, why should you come to the High Court?
Lords, there is one judgment, lords.
No,
which
that
says-
is unfortunately that's what. There is a procedure contemplated. Why should we bypass it and
No.
pass orders? Because the court would be knowing, the court where your case is pending,
Please.
whether there is any flight risk or any other thing, which they will be doing it. Sitting here under 226 without even knowing about the factual aspects, how will the court pass an order?
May I request,
I've seen
lords?
the judgments.
Lords, this is one judgment, lords, of
And there is a division bench judgment. Have you seen that?
please
There is a division
I have
bench
judgment.
judgment.
I have given, sir.
copy.
Look at that. Give it to him. Tomorrow?
Day after.
Day after tomorrow.
Day after.
I passed orders basing on that. Yes, next.
Please.
Seal number 67. Prashant Hasmani.
I am for the respondent, my lord.
Yes.
Your Lordship, in this, I'm challenging the Annexure C, Your Lordship, order passed by the Labour Court, Your Lordship, awarding 1 lakh.
17-1.
Please, Your Lordship.
Yes, this is matter next week. Yes, next.
My lord, the amount deposited may please be released.
Next
The
week.
respondent died.
Yes, next.
Seal number 69.
Yes.
69 RM
The
Kulkarni.
petitioner, my lords, challenging the subdivision of 2 properties. My lords,
Ready?
my lords, ready, my lords, but the impugned orders are in Kannada, my lords. If your lordships has it on Monday, my lords, we'll file a
This
transcript.
is matter on Monday. Or the council will issue by the translated copy of the impugned order.
Please.
Seal number 70.
Interim order may kindly be extended, my lords. Interim order may kindly be extended.
Yes, 70.
70. NP Vivek Mehta. PP Vadavi.
39-1 and application has been rejected. The grant is made in my favor.
It can be
Grant is
taken,
made because I am illegal occupation of
can be
unauthorized.
taken tomorrow.
Tomorrow.
Please.
Tomorrow.
Please tell.
11.